Good morning. I call this meeting to order. I hope everyone had some good time last night watching through all the numbers. And have some good sleep. Welcome everyone to the Committee of Adjustment meeting of October 22nd, 2019. My name is Ron Chatta, Committee Chair for today's meeting. This is a meeting of the Committee of Adjustment. The Committee of Adjustment is composed of 5 citizen members who are appointed by the Brampton City Council. The committee is authorized by the Ontario Planning Act to consider applications for minor variance from the provisions of the City of Brampton zoning bylaw. The committee also consider applications for consent, sometimes referred to as land division applications, which includes severing a new lot from an existing lot, a lot addition, easement, mortgages, or leases in excess of 21 years. I would like to introduce the committee members. To my immediate left, member Mr. Rod Power. To my immediate right, member Ms. Anna Christina Marcus. And my name is Ron Chatta, Committee Chair. Member Desiree Droffler and David Cope are absent from today's meeting, and they have sent their regrets. Seated at the table in front of the committee is Ms. Jeannie Meyer, Secretary-Treasurer of the Committee of Adjustment. And seated near the podium, we have city staff who will assist the committee today. And we have our Commissioner of Planning, Mr. Richard Forward. And the staff, if you can please make your introduction.
Thank you, through you, Mr. Chair. My name is Elizabeth Corazola. I'm the Manager of Zoning and Sign Bylaw Services.
I'm Carolyn Crozier, Manager with the Development Services.
My name is Yin Xiao, Planner 1, Development Services.
Stephen Dykstra, Development Planner.
Thank you. The next item we have the adoptions of the minute. Minutes of meeting held on October 1st, 2019 has been included in and presented in today's agenda. Committee members, any question, comment, concern? Seeing none. If not, then looking for a motion to proceed. Motion to proceed. Adoptions of the minutes meeting held on October 1st, 2019 by Mr. Power, seconded by me. All in favor? Okay. The next item we have the declaration of interest under the Municipal Conflict of Interest Act. Does any member have a declaration of pecuniary interest or to declare on any matter being discussed here today?
None.
Saying none. Now we move on to withdrawals and deferrals. We have 2 written requests. Am I correct, Ms. Myers? The first we have is 14 Hillcrest Avenue, application A19148. Does anyone present here for 14 Hillcrest Avenue? Good morning.
Okay. I represent the owner of the property at 14 Hillcrest Avenue. We request a deferral of the hearing to the next available date. Reason being that the owner is looking at making some amendments to the design that may affect this variance.
Sure. Committee members, any question, comment, concern at this point? Seeing none. Anyone in the audience wishes to speak on this application? Seeing none. Staff?
Through you, Mr. Chair, staff is happy to work with the applicant on potential changes, and we have no concerns with the deferral.
Okay, thank you. If no other comment or concern, looking for a motion to proceed. Motion to defer to the next hearing, which is November. Ms. Myers?
Through the chair, if I may, for the hearing date of November 12th, we don't have enough time for the applicant to provide any amendments to that application. So perhaps we might want to move it to the next hearing.
In December?
Correct, for December 3rd.
Can we put something up to December, so in case if there's minor change, and if they can come back in November, they still
Through
can?
the committee, if that is the will of the committee, that is through the chair, yes.
Sir?
So it's November 12th then, or?
So here's the thing, if we, for example, if the committee go ahead now and defer to November, and if you come back with some changes, there might not enough time to circulate the notices and stuff.
I see.
So what I'm suggesting at this point, what you should request is up to December hearing, and is that December the 3rd, Ms. Myers?
December
Through the chair, that is the date for the
Yeah.
next available hearing.
Okay, and we have only one meeting in December.
That's fine.
So I think what is appropriate at this point is up to December the 3rd. In case there are minimum changes or minor changes or no changes, you can still come back within the time in November's hearing. Otherwise, the December hearing is there for you.
Great, yeah.
Okay.
Thank you.
Okay, so looking for a motion to defer up to no later than December the 3rd. By Mr. Power, seconded by Ms. Marcus. All in favor? Stephanie?
Thank you.
No problem. The next,
That would be A 148, right?
yeah, A9148. The next written request we have is application A19099, 62 Progress Code, adjourned for an addition 60 days. That's what is being requested. Soto, architect.
Hello,
Hello.
good morning, everyone. My name is Fausto Cortez. I'm the architect representing the owner in this matter.
I know you have sent in the letter, but you think we can achieve something which was not achieved before?
I think so. We're dealing with a multi-generational decision on the other hand, on the other side of the table, so it's taken a lot longer than we thought. It just came to light probably about a month and a half ago. We've been working quite diligently to try to get them to the table at all. So now they're open to the possibility, and there's been discussions, but one generation is thinking a little bit different than the other generation, so it's taking us a little bit longer than we thought.
Sure.
It has been moving in the last number of weeks because we've been pushing them to try to make this date, right? Make a decision prior to this date, but we weren't able to come to a resolution so quickly.
Sure, let me ask committee members. Committee members, any question, comment, concern at this point? Seeing none. Anyone in the audience wishes to speak on this application? This is application A19099, 62 Progress Code. Seeing none. Staff, could you please weigh in your comments regarding an addition of 60 days approximately? That's what the adjournment they're asking for.
Through the chair, we heard this application back in June of this year, requesting a deferral to this date. And now we're having another deferral request to another later date. Staff can be supportive of this deferral, but we're asking that the applicant at this time provide us with a bit harder of a date because we do not want to defer this yet again.
Exactly.
If it's 60 days, then we would like to stay to 60 days, no longer than that. And 60 days to the filing date, perhaps, versus 60 days to the actual hearing date. So that, and I would like to have a commitment from the applicant to a date so that this isn't deferred again. This application has been going on for several
Quite some
years
time,
now.
yep.
Prior to the minor variance, there was a site plan that has been ongoing for a substantial amount of time. So we would like to have a date from the applicant, a hard date as to when the filing date could be, as to then we will be making our decision. There won't be any deferrals after that.
So between our previous deferrals, the applicant or the property owners, were they in contact with the city and going back and forth on?
No, the only communications that we had since the actual hearing date of June 18 was the letter that we received yesterday on October 21st.
So this is not the way we work here. if we are giving the deferrals, yourself or your property owner better be in touch with city. Otherwise, I'm sorry, but we won't have any sympathy with your application.
I understand. We worked with staff for, like Stephen said, many years already on this application. And, you know, the position of staff is very, very well documented. And our position is we can't do anything greater to facilitate any more requirements without additional land. And that was our only avenue. When we deferred last hearing, we deferred for the possibility of finding alternative parking solutions, which we have, which they are currently using.
I hear you, but
Yeah.
at the same time, you or somebody else on behalf of the owners
Yes.
could have notified the staff. So maybe there's some solution at staff's end, or at least when you ask for a deferral or some more time to be lenient, at least they are more comfortable
I understand.
suggesting you something or suggesting us something.
That's our
Right.
fault. Sorry about that.
Without any, no, that's okay, I understand, and thank you for acknowledging that, right? So end of the day, we all work together to find a solution,
Okay.
all right? We just don't want to go ahead on something which, and especially this committee and myself, we like to help the businesses, so as the city. That's what my understanding is. So it's not that the last minute we come just through a letter and then just, you know, and if we go ahead with another 60 days, like 55 days or 50 days from now, another letter goes to the staff. I'm sure they're here to help. We are here to look, and you are there helping at your best capacity to the property owners, but everyone need to be responsible. Okay?
Committee's comments are well noted, and we'll stay more in
Appreciate
contact with the staff.
Appreciate it.
What's
Any,
the next, I'm good with it, I just don't know what's the next step.
okay, so 60 days,
What's that, yeah?
Ms. Myers, I think that will take us to January hearing?
Through the chair, I can advise that the last hearing in December is December 3rd, bearing in mind that information, any new revised information is required to be submitted to staff no later than November 5th. The first hearing in January is scheduled for January 7th, although we do request that additional information be submitted no later than November 26th. We have compressed timelines as we approach the holiday season, and we have to bump up our schedule somewhat to accommodate any revised information.
So I would suggest for January the 7th, not that I want December meeting to be a bit easy. So,
Can
sir, do you
Can we
understand?
do the following meeting in January to give us more submission time?
Through the chair, the
Sorry,
following
one
meeting.
person at a time, sorry.
Sorry. The meeting that the agent is referring to is scheduled for January 21st. Filing submission deadline for new information is December 10th.
December
December
10th.
10th.
Okay, Ms. Marcus, you had any question?
Yeah, I was just, January the 21st means that we're giving you a lot longer to plan than the 60 days that you're requesting. And that's something that we were kind of trying to stay away from.
But I do understand, Ms. Marcus, where you're coming from, but their submission time is December the 10th because of the holidays.
Right.
Yeah, so this is something in the situation. So look, sir, we are okay with your request for the final time,
Okay.
but don't let us down.
I won't.
Okay.
Thank you.
So, committee members, motion by Ms. Marcus for January 21st.
Yeah, with the note that it will be the last time that we will reconsider an
And
adjournment.
seconded by Mr. Power. All in favor?
Thank you, committee. Have a good day.
Thank you. Anybody else here seeking for deferral? Yes, sir. Your name and address for the record, please.
Good morning, Mr. Chairman, members of the committee, municipal staff, ladies and gentlemen. My name is Maurizio Rogato, principal of Blackthorn Development Corp., registered professional planner. I apologize for the imposition on your agenda, as I have not filed a written request for deferral. However, I would like to table a request for deferral for application 173.
Mhm.
The reason is to have the opportunity to meet with municipal staff to discuss the requested variance and to discuss their comments, and perhaps also to have the opportunity to review any written submissions which have yet to receive. I do apologize again for committee for the late request. I had to seek instructions from my client, and I have now received those instructions, and we would respectfully request a deferral.
Okay, so this is 8627 Mississauga Road, application A19173. Committee members, any question, comment, concern at this point? For the record, we have some letters here, and one is concerned neighbors 8649 Mississauga Road. They had some concerns, amount of noise from the vehicles being moved various times from early morning until late in the evenings. Let me ask first if anyone present here. Anybody here for application A19173, 8627 Mississauga Road? Morning.
Hannah Davenport, Council for 8637 Mississauga Road. I think we sent a letter yesterday.
8637. Okay. Okay. Anybody else? Seeing none. So we have another concerned neighbor with several concerns. Their address is 8643 Robert P. Fotley. I'm sorry for my pronunciation, but they have also some concerns. So if Ms. Balfour, if you please allow me to talk to the gentleman, and then we'll proceed. So, sir, what you want in this circumstance? As you have seen, there are some concerned neighbors, and the legal counsel is also representing one of the neighbors, I guess.
Through you, Mr. Chairman, absolutely. I'm cognizant of the concerns. In fact, I have not had the opportunity, and I am not in possession of any of the written comments, so I would like to respectfully request a copy of the written comments for my review. And I also would like the opportunity to discuss this proposed minor variance with municipal staff, as I do believe there could be some common ground. I have found examples, not that precedence or common law guides this committee, but examples perhaps might be of assistance. On Heritage Road, where municipal staff has recommended approval of a very similar variance, albeit with conditions. Therefore, I think that the allowance of time, to first allow me the opportunity to receive the written comments, which I do not have in my possession, would be a question of fairness to allow me the opportunity to read that and be better prepared with those concerns and try to address them, and B, to have the opportunity to discuss the proposed variances with municipal staff. And lastly, what I'll say, and I thank the committee for their indulgence in my comments, is that perhaps through those discussions there could be a amendment to the application. Therefore, committee may wish to consider a prolonged deferral to December. However, I'm in your hands. I would also accept a November hearing date, as I do recognize the request has come a bit tardy.
Okay, so you would prefer December the 3rd in case the committee wishes to grant a deferral?
Correct. There could be an opportunity here based on what I've read from prior applications that have been considered by municipal staff at least, for perhaps there be an amendment to the application or conditions imposed, to be considered by committee. But, most importantly, I have not received any of the written comments, and I really would like the opportunity to read those comments and to consider the same. As a planner, we're tasked with coming up with our own professional opinion, and unfortunately, I'm remiss when I see two professional planners with two different opinions. It sort of doesn't serve committee well. So I'd like the opportunity to try to discuss the application.
Sure. Let me ask some question to the staff or staff's opinion, and then we can probably come back to you. So staff, what's your opinion about the agents is requesting a deferral to December's hearing? And after, I would like to ask Ms. Myers about the submissions. Then of course, we have legal counsel representing one of the owner. But after staff, I'd like to ask Ms. Corozola if there is some notice of violation on the property. So staff, could you please weigh in your comments?
Well, through Mr. Chair, staff understand there are the materials just mentioned, and staff are happy to review that with the applicant and see if there's potential solution to address staff's concern. And we are supportive of the deferral to December 12th.
December 3rd, I believe.
Sorry, December 3rd.
Okay, no problem. Ms. Corozola, if you could please weigh in if there is some history.
Thank you. Through you, Mr. Chair. Yes, there is some history. There has been a zoning violation notice forwarded to the owner, and the matter is with it being actively enforced at this point in time. There was an extension to the compliance deadline that was originally imposed to allow the applicant an opportunity to consider options and potentially make this variance application, which is where we land today.
Thank you.
And through the chair, just for the record, I will be pleased to provide the correspondence to Mr. Regato now that the letters have been made part of the public record.
Okay. So in the event for December 3rd, what is the last submission day?
Through the chair, for the December 3rd hearing, the last submission date is November 5th for any amendments for the application.
Okay, November the 5th, October 22nd. So now we would like to go back to the legal counsel, Ms. Brahmanpur from Davis and Webb.
Morning again. Through you, Mr. Chair, I don't think we opposed a deferral per se. I do understand that the applicant is requesting time to speak with staff and hopefully with the neighbors to try to resolve concerns and issues. However, there are concerns on the part of the neighbors with respect to the use currently on site, as it is causing the neighbors nuisance and there are other adverse impacts. So our preference would be the next reasonable date that could be scheduled. We don't want to prolong this much further. So that'd be our request.
Okay, thank you. So committee members, any question, comment, concern at this point? Sir, for December the 3rd, you know the submission is November the 5th?
Yes, Mr. Chairman.
So you need to be active in order, like, it's roughly about 2 weeks.
Absolutely. We look forward to meeting with municipal staff at the earliest opportunity. And also, forgive me, I did not mention the neighbors, and we definitely wish to speak to the neighbors to try to aid their concerns. I've visited the site countless times, and frankly, I find it to be in a pretty orderly format.
Okay. No problem, committee members. If no question, comment further, then we'd like to move motion to defer to December 3rd by Mr. Power, seconded by Ms. Marcus. All in favor? This is deferred to December 3rd.
Thank you.
Welcome. Okay. Anybody else for the final time? Anybody for any deferral or withdrawal? Seeing none. For those unfamiliar with the Committee of Adjustment procedure and process, I would like to give a brief explanation and scope following some procedural matter that we have already undergone. The Secretary Treasurer will call the applications by announcing the application number, the name of the applicant and address of the property subject to the application. The applicant or authorized agent representing the applicant will then come to the podium, state their name and address for the record, and then present the applications. I request that you reserve any question or comment pertaining to the staff report until after planning staff has had an opportunity to present. If there is anyone in attendance who wishes to speak to a particular application, you will be given the opportunity to do so when the application is presented. Any decision made here today may be appealed to the local planning appeal tribunal. previously through the Ontario Municipal Board. Appeals are received in the City Clerk's office associated with minor variance and consent application will be processed and forwarded to LPET. This process may be commenced with Secretary Treasurer by filing a completed appeal form and filing fee within the prescribed 20-day appeal period. Information pertaining to the appeal process may be obtained by contacting the Secretary Treasurer within the City Clerk's office. Now we move on to the new consent applications.
Calling application B18013, Pralhat and Anita Kapoor. The property is located at 28 Stephen Court.
Good morning, my name is Manny, and I'm here to represent the owner of 28 Stevens Court. We are seeking a consent to separate. I'll be happy to answer any questions.
Sure, committee members, any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Seeing none, staff, could you please weigh in your comments?
Through Mr. Chair, the application B18-013 is supportable. And apart from the standard conditions of Secretary Treasurer, staff recommend the following conditions. Number 3, prior to the issuance of Certificate of Secretary Treasurer, arrangements satisfactory to the Region of Peel, public works shall be made with respect to the location and existing and installation of new services and or possible required private service easements. And number 4, that prior to issuance of the Certificate of Secretary Treasurer, a plan be submitted depicting the driveway connection on the severed lot, including the existing boulevard, sidewalk, curb cut dimension, and existing utilities, if any, to the satisfaction of the Commissioner of Public Works and Engineering. Thank you.
And I guess these drafted conditions by Secretary Treasurer are the same. And sir, do you understand and accept these conditions?
Yes, I do.
Okay, if no further discussion, looking for a motion to proceed. Motion to
approve the
Staff's
application
recommendation.
with the staff recommendations.
motion to approve with the staff's recommendation by Ms. Marcus, seconded by Mr. Power. All in favor? This is approved. Thank you.
Thank you.
Calling applications B19010 and related minor variance applications A19069 and A19070. Bharat Shala Corporation. Property is located at 32 McLaughlin Road North.
Morning.
Good morning. My name is Kamlesh Sidani. I'm the authorized agent for Bharat Chawla Corporation, and we're requesting a severance of 32 McLaughlin Road North. And by severing the property, it creates about 3 variances on the retained lot and the severed lot. And the variances are that you require 30% of the lot coverage. On the retained lot, we have 30.58%, and the severed lot is 30.57, so which is very minor in nature. The other 2 variances are due to meeting the requirements of transportation services, which creates a hammerhead and a wider driveway, and therefore eliminating the 600 millimeter landscape strip between the 2 lots.
Okay, so altogether you have 3 applications. Now we are discussing B19010, and I guess later on A19069 and A19070.
That's right.
Okay. So any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Seeing none, staff, could you please weigh in your comments?
Through you, Mr. Chair, first of all, there is a correction to be made on the staff report. So condition number 3 now will be taken out, as the conditions set out under number 3 would be taken care of at the site plan stage.
Okay.
So that leaves conditions number 1 and number 2, which are the standard condition of the Secretary Treasurer.
Okay, and we have some drafted conditions by Secretary Treasurer as well.
So we also removed number 3.
So staff, could you please go ahead with the conditions, if you can read them?
Of course, yes. So the application is supportable, subject to following conditions being imposed. Condition number 1, that a Secretary Treasurer's certificate fee shall be paid in the amount current at the time of the issuance of the certificate of the Secretary Treasurer. Number 2, that approval of the draft reference plans as applicable, together with the terms of any associated easement, shall be obtained at the Committee of Adjustment Office, and the required number of prints of the resultant deposited reference plans shall be received.
Okay, so do you understand and accept
Yes.
these conditions?
Yes, and we agree to all the conditions.
And did you get the opportunity to?
Yes.
Okay, and you agree and understand these conditions as well?
Yes.
Ms. Corzola?
Thank you, Mr. Chair, through you. Just in respect to the conditions associated with the related variances, I do note that the condition that would typically be here, which would require that the consent application B19-010 be approved and finalized. I would hate to see approval of the variances left that applies to the property without the finalization of that consent to sever the land. So my request on both variance applications would be that you add a condition to require approval of the consent.
Okay, so but we are just looking consent application. We are not, we're not looking at all three applications together, right?
Through the chair, respectfully, I did call all three applications because
Okay,
they are
I missed that.
related. We have just gone through the consent application. Staff revised the conditions to remove one of their conditions that was in the staff report. We're now looking at the minor variance applications.
Okay. So any question, comment, concern, committee members? So do you understand and accept
Yes.
this amended condition suggested by staff?
That's right.
This one for the final time, staff, is there anything else besides staff wishes to add?
Through Mr. Chair, so staff are supportive of the associated minor variance applications, and we have the following conditions. First, that the extent of the variances be limited to that shown on the sketch attached to the public notice. Number 2, that number 2, the associated consent application B19-010 be approved and finalized. Number 3, the failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Okay, all good, I guess, at the agent's perspective and staff and the committee? If no further discussion, looking for a motion to proceed with these applications. Amended recommendations. Motion to approve with staff's amended recommendations by Mr. Power, seconded by Ms. Marcus. All in favor? This is approved. Thank you.
Thank you.
Calling application A18-001, Godfrey Matthias. Property is located at 97 River Road.
Good day, Mr. Chair, members of the committee. My name is Joel
Morning.
Tanner with the Office of Simple Design Studio, client's authorized representative for the file.
Just if you can please give me a few seconds. I'll
Yep,
be
no problem.
right back with you. Okay, sir. Would you like to add anything else beside your application?
Just very minor. We've been at this file for about just over 2 years right now, working pretty collaboratively with the city planning staff, building officials, as well as Conservation Authority in order to get this project moving forward in the right direction in order to ensure everybody's satisfaction on the file. And it seems as though it's been a pretty valiant effort, and we've hopefully made it to where we need to be.
Okay. Committee members, any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Sir, if you can please come forward if you are for this application. Just on the record, I have concerned neighbors from 102 River Road showing their concerns, Jerry and Catherine Smetka, and also we have concerned neighbors Don and Iha Nellor, 89 River Road, showing their concerns. And for the record, I would like to include their letters. And just also on the record, we have no concerns and no objections from the Credit Valley Conservation. Sir, your name and address for the record, please.
Thank you, Mr. Chairman. I'm Don Naylor, represent my wife and myself. I forwarded a letter to the committee expressing my concerns and my observations about this file. I'm a 30-year resident in that location. I also own 91 River Road. My comments are pretty specific and very clear, and I'm anxious to hear how this unfolds. So I'll wait my turn to comment.
If you would like to add something, you can certainly ask, because staff is going to respond after, so maybe they can also answer some of your concerns.
May I ask some questions to staff right now?
Sure,
please?
you can, but
Yeah,
obviously...
Grab my note.
Yeah, okay, please go ahead, no problem. At this point, what I would like to do, I would...
Is there a physical copy available of the letter? We don't have any record of it.
Staff will provide you after. Staff will provide you after.
Okay.
Yeah. Sir, back to you.
Thank you, Mr. Chairman.
No problem.
Question for staff. Did staff attend to an inspection of this property?
I believe they do, but they will answer. Please carry on.
And did committee have an opportunity to inspect this property as well?
Yes, sir. We do go out and visit sites.
Thank you very much. In the process, was the title document for this property ever considered when this application was being reviewed? In other words, what was on title on this property with respect to bylaw violations or anything else with respect to the accessory building?
When the property been purchased? That's what you're saying about the title?
This property, correct, on this file.
I guess what my understanding is, when the lawyer closed, if there's anything on the title, obviously they raise their concerns. They would have raised their concern at that time, but we will get to hear from the staff if they have something in their knowledge, or if at the time, if there was something against the title register or any violation at that time.
I think it's important that it come out in this presentation today that in my letter it was very clear that I supported a portion of this application as a neighbor and as a person familiar with this property. But there was one very contentious point, and the reason of my question was that if a lawyer did his job and the title information with respect to zoning violations, previous construction on this property for this gentleman purchased it, then he wouldn't necessarily know whether or not there were violations on it, would proceed and do various things without being aware of it.
But I guess if there's any violation, the municipality has the record for that, regardless of, even if there's any violation 10 years back on any property. Even I live in a property, but I guess the municipality has always the record, like when was the notice being issued. We'll get to hear the staff, and maybe you will get some answers for your questions. And then you can obviously come back and ask further questions, or if you need more clarification.
Appreciate that. Thank
Okay?
you, Mr. Chairman.
Welcome, no problem. Anybody else for this property, this application? Seeing none, staff, could you please weigh in your comments? I see there's a lengthy recommendations.
Yes, thank you, Mr. Chairman. Staff is of the opinion that the requested variances do meet the four-part test under the Planning Act, subject to the recommended conditions, which are the following. Number one, that the extent of the variances be approved limited to that shown on the sketch attached to the public notice. Number two, that the oversized accessory structure near the river shall not be used as a separate dwelling unit, and habitable space in the accessory building shall be strictly prohibited. Number three, that a building permit for the accessory building be obtained within 60 days of the final date of the decision of the committee. The permit shall include removal of all existing plumbing fixtures within the accessory structure and removal of the water service from the home to the accessory structure. Number four, the removal of all habitable space and plumbing and water lines associated with the accessory structure is to be completed prior to issuance of permits for the new proposed dwelling unit. Number five, that the owner demonstrate compliance with the Ontario Heritage Act through either a scoped HIA or a letter provided by a member in good standing. I should note for the members' benefit, I did not explain this commission within the body of the report, but the River Road Cultural Heritage is listed, and that's why the HIA or a letter is required.
Okay.
Number six, that the owner shall provide a tree inventory and preservation plan. Number seven, that the owner submit a grading and servicing plan prepared by a PEng or an Ontario land surveyor for approval by the Public Works and Engineering Department prior to issuance of permits for the new dwelling unit. Number eight, that the owner secure custom home approval prior to issuance of permits for the new dwelling unit. Number nine, that the owner secure the required permit from Credit Valley Conservation. Number 10, that drainage from both the new dwelling unit and the existing accessory structure be directed onto the subject property, and drainage on adjacent properties not be adversely impacted. And finally, number 11, that failure to comply with and maintain any of the commissions of the committee will render the approval null and void.
Okay, so sir, if you can please come near the podium. Do you understand and accept these conditions?
We do, yes. Just to reinforce, we have not seen the letter from the neighbor, but we do feel that we've done our due diligence in the process, and that the home is minor in nature and the impact, and we are dealing with the building that was previously approved by conservation down below.
Okay, sir, if you can please come back here and. The gentleman, the concerned neighbor, raised some questions. Can we address them at this time, Ms. Corzola or Ms. Jenkins?
Thank you, Mr. Chair. I'll certainly address any outstanding violations. I can confirm that the property has been under investigation since 2017 by the Building Division for construction without a permit. At this point in time, there has been no order to comply issued, although construction has proceeded. Immediately following the initial investigation, this application for variance was filed. Certainly staff have had many discussions with the applicant's representatives about the nature of the use of what is meant to be an accessory structure. It is for all intents and purposes, it should be used for storage or in any event not used as habitable space. And obviously the three-season room or three-season home that's been created there is not in compliance with the zoning bylaw, and there has been no variance requested to allow it to remain as a secondary dwelling on that lot. So we will be requiring, and as imposed in the conditions recommended by planning staff, that all of the associated plumbing and water lines be removed from that building, and that the storage shed in fact be returned to an accessory building, not a secondary unit. As far as checking title on the property, no, planning staff and certainly zoning staff have not reviewed title. We do have a record of any orders that have been issued or enforcement action associated with city activities. There may be other restrictions or encumbrances on the property that would be registered on title. I also don't see as part of our record any request for a due diligence check as part of the sale of the property. We do typically get requests for compliance letters, so that was not done in this case. If the property has changed hands, the city would not have been involved or been able to confirm any associated violations that we are aware of.
Okay. Sir, I hope staff had answered some of your questions.
Well, I'm a little disturbed because there's no reference in that report, and thank you, staff person, for that, going back to when this whole problem started, which was 10 years ago, when this house, the original building, was torn down, reconstructed over a long weekend, and a huge green tarp put over it so nobody would see it. And I live right next door to it, and I saw it. I reported it. And they stopped work on it. It sat that way for 10 years, like a bomb it did at a construction site, debris everywhere. And I thank our new owners for cleaning it up and making it look like a proper property. Thank you very much. Because from my perspective, 10 years we looked at that, and it was a mess, it was a nightmare. So that's the positive part of this application. But the unfortunate part of it, from my perspective and everybody's perspective, is that this is not a lawful building, not a lawful piece of construction 10 years ago, and I'm hearing there's no record of that. That disturbs me. It should disturb all of us. This building should not be there. But it is there. So are we asking for permission, or are we asking for forgiveness?
I guess in this lengthy staff recommendations, if you, did you get that chance to go through the staff recommendations?
I have the staff report.
Yeah. So, you see, during all these, when I read these recommendations again, like staff has, especially the planning, has some sort of good control on how the procedure is being followed at this point, like all these conditions. I guess I am at least convinced on this note, but I do understand where you're coming from as a concerned neighbor, and especially your family is there since 1990, and I fully understand and where you're coming from, and thank you for doing that and keeping an eye and altering city if there's any wrong activity you notice. Given the fact that staff are the bylaw inspectors, they act on the basis of the complaint, right? I'll ask one more time, as you mentioned, like you notified city 10 years back, but right now the situation is, I don't think so. The committee can speak about 10 years situation about 10 years back. Obviously, they are here for seeking these variants, the current owner, and we can only speak and discuss what is in front of us. This committee does not have other jurisdictions, but obviously when we make our decision, we do get to hear all sides of the story and all your concerns you have brought. That helps us, and obviously that helps staff as well.
Thank you, Mr. Chairman. I do have one request.
Sure.
My final comment on my letter on this application was a concern for the electrical in this building. It was never inspected to the best of my knowledge. Neither was the framing or any of the other work that was done in that building. It was supposed to be brought into compliance. We never heard whether or not it was. But the electrical has not been inspected, and there's a fire. We're all going to lose our homes. Okay, it's in the forest, climate change, the heat, and all those things. If this applicant would be good enough to also be required to provide an ESA clearance on the building, then I'd have some comfort level in knowing that it complies.
Sure. No, that's a fair request, and I understand and fully agree with your request. But I guess in the site plan process, when they will require for the permits, is there something we can?
Through you, Mr. Chair, this property is not actually subject to site plan approval. It is subject to a building permit. All of this structural and framing and any items covered by the Ontario Building Code will be reviewed. The Building Code doesn't deal with electrical, so if that would be under the authority of the Electrical Safety Authority. So if you are looking to verify, I would recommend adding a condition.
Please do that.
Certification from the Electrical Safety Authority be confirmed for any electricity.
Yeah, certificate from Electrical Safety Authority. And they need to submit a copy for the record.
Correct. That would be a requirement prior to the completion of this, and certainly prior to the issuance of any building permit for the principal dwelling that will ultimately be created. I do want to note, sorry, if I may, through you, Mr. Chair, just for the applicants, for the concerned neighbors, comfort, we do have a record of the complaint and the enforcement action from back in 2007 as well. There was an inspection, there was ultimately a request for a building permit application was submitted, but that did fall off the rails and was not pursued at any point in time. So acknowledging fully that this building has been constructed without any approvals by the city and certainly without any of the required inspections, there may be a need for things like footings and foundations or, certainly any of the support structure to be uncovered. Likewise, the framing may need to be exposed on the interior of the building. So all of that would take place through the proper building inspection process following the issuance of a permit.
Sir, I hope all these comments gave you some sort of comfort. And
Thank you,
we are
Mr.
happy to
Chairman.
include Electrical Safety Authority certificate.
They do, and I hope applicant agrees that that's a reasonable request.
Yeah,
I thank them again, and I look forward to being good neighbors. Seriously.
And thank you for coming and bringing all this history as a concerned neighbor.
A little bit of history.
Well, 30 years is a lot of history. Sir, please come forward. Do you understand and accept all these conditions?
Fully.
And you understand that you need to provide at some point certificate from Electrical Safety Authority?
Correct, yeah, the only request that I would put out there would be regarding, I'm just gonna grab the item number here, regarding the 60-day interval with light item number 3. Not sure how reasonable it is to obtain a permit. We could easily apply for a permit within 60 days. Whether or not it is granted within 60 days because of the eccentric circumstance and engineering site visits for truss sign-off, foundation sign-off, etc. I wonder if we could just reword that to include the application of a building permit within 60 days as opposed to the approval, just because that is subject to city staff review timelines.
Staff?
Thank you, through you, Mr. Chair. I would prefer an extended time frame to receive a permit. We have a number of instances where people will make an application for a permit, which will then clear that condition, but not pursue that application. So 60 days for a 10-day turnaround for a permit is certainly something. We're talking about just the permit here for the accessory structure, not for the principal building. So I would be happy to extend that, and I'm sure building division staff would not have any objection to a 90 or even 120 days time frame, but I think it should be to the issuance of the permit, not just to the application.
Sure. Yeah, if we can go with 120, that would be perfect. Gives us a bit of flexibility.
Okay, we're okay with 120. Ms. Jenkins, you wish to add something? So just for the record, the condition to be added about Electrical Safety Authority, is that to be read as number 12? Recommendation number 12, or?
It could certainly be added as condition number 12. I would recommend that it be phrased as condition number 11, and then condition number 11, which is our standard, be moved to
Exactly.
12.
Okay. Do you understand and accept all these conditions?
We do, yes.
Okay, so looking for a motion, if no further discussion, looking for a motion to proceed. Motion.
A motion to proceed and to approve the application with the staff recommendations.
With the amended staff recommendations.
Amended staff recommendations.
Motion to approve with the amended staff recommendation by Ms. Marcus, seconded by Mr. Power. All in favor? This is approved.
Thanks so much, Committee.
Thank you. Work with your neighbors. Thank you, everyone.
Okay.
Calling application 819 North 71, Michael and Yin Zhang. The property is located at 92 Laurel Crest Street.
Hi, good morning.
Good morning.
I'm Michael Zhang, and I'm the owner of the 92 Laurel Crest Street.
Okay, would you like to add something beside your application in front of us?
No, not now.
Okay. Committee members, any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Seeing none, staff, could you please weigh in your comments?
Through Mr. Chair, the application is supportable, subject to the following conditions being imposed. One, that the extent of variances be limited to that shown on the sketch attached to the public notice. 2, the owner shall obtain a building permit within 60 days of the decision of approval. 3, the side entrances shall not be used for an unregistered second dwelling unit. 4, the failure to comply with and maintain the conditions of the committee shall render the approval null and void.
So do you understand and accept these conditions?
Yes.
Okay, if no further business, looking for a motion to proceed. Motion by Mr. Power. Motion to proceed with staff recommendations, seconded by Ms. Marcus. All in favor? This is approved. Thank you.
May I ask one more question?
Sure.
About this item 2, the 60 days. And it mentioned I should obtain a building permit within 60 days. Does that mean I should put it in the application or should get the permission?
Ms. Zola?
Sorry about that.
No problem.
Thank you, through you, Mr. Chair. The application for a building permit can be submitted now at any time following committee's approval. We would not be in a position to issue the building permit until after the appeal period expires. But certainly if a permit application was received anytime in the next few days, it would be able to come across the counter by virtue of this approval.
Yeah.
So,
I guess you're fine.
Thank you.
Okay. Thank you.
Calling application A19-172, Brad Rideout and Pamela Perry. Property is located at number 2 Sheepberry Terrace.
Good morning.
Good morning.
Your
My
name
name
and-
is Brad Rideout, I'm the homeowner of 2 Sheepberry Terrace.
Okay. Yes, Mr. Homeowner, how can we help you?
So we submitted a minor variance to put an in-ground swimming pool in the backyard. The issue arose because we're on a corner lot. There's a triangular area, I guess, where it's restricted to have an in-ground pool. So the pool company actually came to get a building permit back in September and ran into this issue, which prompted us to submit the minor variance application. So that's where we are today. It's a very small section of the backyard that actually includes the variance, less than 10% of the actual area of the swimming pool. And I've also got letters of approval or support, I guess you could say, from the neighbors that would be affected, that are adjacent to my property. So,
do you have with you?
I submitted the letters with the application. I do. They were attached to the application.
Yeah.
So for
That's
both
part of the
properties that are adjacent to ours, 4 Sheepberry Terrace,
Yeah.
as well as
161 Eden Brook. Yep.
Yeah, and 161, that's the property of concern, I guess, which is right behind our house, which is, their property is set back a little farther from Edenbrook Hill, which is causing this area of concern.
That's good. Thank you for bringing this detailed application. Committee members, any question, comment, concern at this point? Seeing none. Anyone in the audience wishes to speak on this application? Seeing none. Staff, could you please weigh in your comments?
Through you, Mr. Chair, staff are supportive of this application, subject to the following conditions. Number 1, that the extent of the variances be limited to that shown on the sketch attached to the public notice. Number 2, that failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Thank you. You understand and accept these conditions, sir?
Yes, I do.
Okay, if no further business, looking for a motion to proceed.
Motion to proceed with
Staff
staff's recommendations.
By Ms. Marcus, seconded by Mr. Power. All in favor? This is approved. Thank you.
Thank you.
Calling application
A19-174, Rashaba Pavar and Suman Pavar. The property is located at number 2 Leinster Road.
Good morning, everybody. This is Salman Ilahi, representing my client. I'm the agent from Conserve Architecture, Inc. Property is basically 2nd Leinster Road. They are requesting for a minor variance to widen the driveway to accommodate 3 car parking side by side. Right now, it is allowed by the zoning bylaw to have 6.71 meter. We are requesting to go up till 7.80. That's the minor variance request.
Okay. Committee members, any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Ma'am, please come forward.
Nervous. Holy smokes.
You're
Played back
all
in
the way-
school. Oh. Okay, hi there. My name is Michelle Rebello. I'm a resident neighboring this home.
Address, please.
116 Cornwall Road. And the
Sorry,
issue...
one second, Ms. Myers, did you get the names correctly?
Through the chair, if I could get the surname of the applicant, the agent?
Please, if you can spell your surname or last name.
Rebello, R-E-B-E-L-O.
Thank you. Please go ahead now.
Okay, this residence has an existing garage, I'm assuming it's a two-car garage, and there is enough space for if they want 3 parking, they could park 1 in the garage, 1 behind, and the rental to the left. This house has been converted into a rental property. The basement is now a legalized basement, so there is coordinated space for them to park their cars on the driveway. The issue I'm having is when I reviewed the plan on the back, there's proposed scope of work, which I guess is not approved legal, whatever, to get it authorized. They want to convert the garage into a living room. We've already had issues in the neighborhood with spaces being renovated for more living and putting borders in. Our concern is this could lead as well to the same situation. A garage was converted directly across the street, and there was residents living in the garage, a border in the garage, downstairs and upstairs. These homes are very small. If you're removing garages from these residents, if it's later for resale, someone, as maybe an elderly person that wants a smaller, accommodating space, will be removed of a garage. So currently my stand is there is space for them to have their cars on the driveway. I think the reason for the variance is because they want to convert the garage into a living room.
That's what I guess the application is saying, to
Right.
convert existing covered
And the
garage.
variance does not, sorry sir, the variance doesn't state that. By chance, I reviewed the document on the back, and it listed all this future work they want to do. So if I was a senior wanting to buy a smaller home, I would want a garage to hide my car. And then what leads to is the space gets messier. There's less space for you to hide your garbage bins, your snow blowers, whatever it is. Mess comes onto the street, which we're all exposed to.
Well, thank you for coming forward as a concerned neighbor. We always appreciate, and because that always gives us more information. Staff will be answering some of the questions. Maybe you can have a seat, not all the way up there this time, if you can sit close by.
Sure.
That'll help. But in terms, when you mentioned that in the future, if some senior is willing to purchase this property, we cannot comment on the future, first of all, and with all due respect to everyone, the future prospective buyers. The buyers do have opportunity whether they want to go forward with any sale, not just this property. It's not that someone being forced to purchase any property. Like this is just we are now, I don't think so this committee has any sort of authorizations to comment on those future sales.
Okay.
But to your satisfaction, staff is fully aware, and any work, for example, is going to happen on this property, city is going to look after everything, and they are fully assessing everything, and that's the reason, I guess, this applicant is in front of committee, because they're working with the staff. So for your questions you raised, let's hear the staff report and what staff has to say about it. Maybe that will satisfy some of your questions or concerns.
Okay, so just a question as regards to them wanting side by side. Are they not allowed to use the garage and have a car inside, park the second car behind, and then the rental to the left? It's a It's not a single driveway, it's a double wide.
So staff will answer that. If you can, if you have anything else to ask,
No,
you can
that's-
ask right now, or you can, if you just step back, and then staff will be addressing some of your concerns.
Okay.
Okay, thank you. Staff, could you please weigh in your comments?
Okay, good morning, Mr. Chairman and members of the committee. My name is Rob Nicky Fortune, development planner with the city, and I'll be looking after the next 8 of the 9 planning reports. So it's correct that the purpose of this variance stems from the fact that the garage is to be converted from a garage to a livable area, and for possibly a second dwelling unit, and for this reason, the applicant wants to widen the two-car driveway to accommodate 3 cars. This is somewhat of a unique property. It's tucked away off of 2 busy roads. There's only a few lots on this side street. There is no walkway, sidewalk on this side. There's a lot of landscaping. One of the reasons we are not supportive of these driveway widenings are because we want to ensure that it's from a proper streetscape perspective, that there is sufficient landscaping. In this particular case, that there is. We are concerned still that converting a garage, taking away the garage door and replacing it with a window and possibly a front door and taking away anyways and not having landscaping might look a little odd. So, and as a result of this application submission, it was noted that in the rear yard that there was a shed that was existing shed that is located a little too close to the property line. So staff have reviewed the variances and believe that they meet the 4 planning tests and can support the variances subject to the following conditions. That first, that within 9 months from the date of the committee decision, the owner shall make arrangements satisfactory to both the manager of urban design and the manager of open space development to demonstrate that the new elevation design and landscape treatment in front of the converted garage has been determined to be acceptable and appropriate for the development of the site. The owner also acknowledges and agrees that the driveway shall not be widened until written confirmation has been provided on the above. Second condition, that the extent of the variances be limited to that shown on the sketch attached to the public notice. And thirdly, that failure to comply with and maintain the conditions of the committee shall render the approval null and void. I just want to raise one other point, is that with regards to the shed in the back, our engineering staff have been out there and have determined that they'll not pose a drainage problem to the adjacent neighbors, and no conditions to that regard are being requested.
Okay. So do you understand and accept these conditions?
Yes, I do understand, and we are fully complied with that.
Okay.
So they're gonna change the garage, right? They're gonna change to a living room.
A livable area.
A living area. And the house isn't sufficient?
Ma'am, you can't talk like that. If you can please come forward. That's not the way it works.
So at this
Any
stage.
comment has to be
Okay.
through me. You cannot communicate staff directly.
Okay.
Okay, thank you.
So has this been approved this, then? Is that what this gentleman is
That's what
stating?
staff's recommendation is. It has not approved yet. The committee is going to make the decision.
Okay, so is it another process that it's reviewed to decide if it is completed, to be completed?
Ms. Corzola?
Thank you, through you, Mr. Chair. Just to give some background as well on this, this is a registered 2-unit dwelling, so there's already a legal secondary unit in this property. The proposal.
So the secondary unit is legal?
The secondary
For your
unit is
information.
legal based on the previous approval, which included the 3rd parking space. So that you have to have 3 parking spaces associated with any 2-unit dwelling, and the 3rd parking space was accommodated in the garage. So, or at least one of the required 3 was accommodated within the garage. Now that the owner would like to convert that garage into living and habitable space, not another new unit, but an extension of what was the principal unit, so they're looking for a little more living area, which is not uncommon, but the conversion of the garage will then result in the failure to comply with that 3rd parking space that would be required for the secondary unit, which is the purpose of this application, is asking for the driveway to be widened by a little over a meter. That's what's before you today, is the widening of the driveway. Conversion of a garage into living space is not a variance. You're permitted to convert your garage into living space, should you choose to do so, as long as you maintain the required number of parking spaces on your property.
Because they are converting the garage, so they are short by 1 parking, and that's why they need that additional parking, so their legality of their second dwelling unit can continue.
That's correct.
Okay, I got it.
Well, my comment on that, sir, is when they approved for the legalized basement, it was based on the fact that they were using the garage as a third parking space.
And
So
that's
now
why they are here again, ma'am.
I'm sorry?
That's why they are here again, to seek another parking spot, because you need to have a 3 parking spot
Yes.
for the second dwelling unit or
Yes.
the legalization.
Yes.
So because they are converting the garage, which is allowed, that's why they need 3rd parking space, and that's why they are here in front of this committee.
Okay. Counselor, as to that, when their first permit was specified, where there's a notice, it was based on a legal basement apartment. Not now that they've gone through other steps to modify, almost to use the system to benefit them, that they can now modify the garage in order to get that 3rd parking spot. Because the neighbors were noticed with those postings that a legal basement was approved, and now they're diverting through to now know that they want to enlarge their living space upstairs, which will be probably another rental property. The basement is already a rental property. The upstairs, I don't know if it's a homeowner that lives there or not, but we have lots of rentals in the neighborhood, and it's appreciating our home values. All and up and down the Cornwall, where we live, tons of rental properties. And you can see a rental property clearly because the home is not maintained, the lawn is not cleaned, and now they want to now remove a garage, which I know you say it has nothing as to this. But how they went about approving the basement for a legal basement, knowing that the 3rd parking space was in the garage, and now they're going to modify it to gain that 3rd by widening the driveway, I find it very deceptive in a sense.
Okay. No, again, ma'am, with all due respect, let me make a correction here. We are not council. We are not up to that level yet, I guess.
Okay.
Yeah, so just to, because maybe you are under impression that we are counselors. So if anything you are not happy, don't get mad at counselors.
I don't know.
We are not counselors. This is a committee.
Oh, so you're a committee then?
Yes.
A committee member?
Yes.
Got you.
And we are not counselors.
Okay.
All right.
Got you.
We are not up to that level, right? So another thing.
Yes.
Sorry, Mr. Power, you would like to add something?
Yeah, through you, Mr. Chair. I think the primary concern that you have, just to simplify it, is not that it's a living space in the garage or an extension of a living space in the garage, which is totally fine. It's that it's going to become a 3rd dwelling in that home. So now you have a basement apartment, you have the upstairs, and then you have a garage that's being rented out as something different.
It could lead to that because it's happened, but my concern is that they're removing a garage.
Ma'am, to answer your question again, let me say that, and staff can correct me if I'm wrong. Their basement is already legal.
Yes.
Based on, they have 3 parking spots right now, and 1 is including in the garage. Now, what they want to do, they want to convert garage into the living space, and which is okay.
Yes.
People normally do that.
Right.
Okay? So having said that, now they are adding the garage into their livable space, so that means they are short of 1 parking.
Yes.
Okay? So they are here to ask for that 3rd parking, and which staff recommendation is, according to the staff recommendation, they are fine with it. The 3 parkings on the, not in the garage, on the driveway. Thank you. So this is why they are here. This garage is not going to be the 3rd portion or second dwelling, they already have a 2nd dwelling unit. It's not going to be the 3rd dwelling unit. This is going to be the part, the livable garage is going to be the part of their existing home. It's not going to be another rental space. And as you mentioned, like there are many rental units. We cannot comment on that because they are not obviously in front of us. We don't have that information, but I do understand, and I understand if you're upset or frustrated. I fully sympathize with you on that note. But we are discussing this application particular, and that basement or the second dwelling unit you're referring to, that is already legal. And I think you asked when that got legalized. Maybe I can ask that question to staff for your satisfaction and for our knowledge that when that got legalized. So, Ms. Carzola, maybe you have that information?
I do. Thank you. Through you, Mr. Chair. The registration became final and was issued on July 23rd, 2019. That was following the submission of their application in 2018 to register, and then a subsequent application for the building permit to construct. We have no record of any previous enforcement history on this property. There was nothing done to construct or use the property for a two-unit dwelling that we have any evidence of prior to making it legal. And likewise, the driveway requested variance, the driveway has not been widened. They are simply here seeking approval today to allow them to do that.
So, sir, when they applied for that first one, what was the status as to the parking at that point? They knew at that point they were having...
We are going backwards again. At that time, the garage was one parking and the two parking outside. Now they wants to add the garage into the livable space, so that means they need third parking. And according to the staff report, staff is fine. They're recommending a positive report in favor of the homeowner that the third vehicle legally can be parked on the driveway. Am I correct? Yes.
Okay. And one other thing was, let me think now.
No problem.
Can't remember what I was going to say. Oh, as to this gentleman who's here is, I guess, representing the homeowner, he currently has these people living in that home. And I know you're going to refer to the future, but when these people sell, right, who's to say the next homeowner won't come in and convert that space into a boarding?
If they do, and if you see any activity,
then I'll have to come back and
feel free
complain,
to notify.
which is the issue we're having with so many rental properties. We're having to modify the depreciation of our homes in our neighborhoods. This is clearly a situation that can result in issues for the neighbors.
But,
and them going by saying they need a third parking spot, they have parking. And I know they want to convert the garage, but if every home in the neighborhood wants to convert their garage into an additional living space, there is no garage. There is the home, the land, the landscaping, everything becomes modified. This is an older residential area, and they're really depreciating the value of our homes.
Ma'am, I fully understand and sympathize with you, but however, if anyone wishes to proceed with converting their garage, obviously they have to come through the city departments, and they have strict guidelines to go through. And if something is not according to the codes, then the committees are here to look at one more time to reevaluate the whole situation. So it's not that somebody can just move your other side of the neighborhood and do whatever they want. That's not going to happen, and our staff is really strict on these things, and we understand that it's not just one property. The neighbors do get affected, and that's why you got notified in your mail, and all the concerned neighbors in a certain radius received those letters. And that's why you have seen maybe while you were sitting up there that many other concerned neighbors came up, or their legal representative came. And this is, I guess, a really good system that where if anything is going to happen with, or someone is requesting something, that the neighbors do get notified and they have the opportunity to come. And that's why I keep thanking that bringing all this information. So I hope we understand, you understand, and you got some more clarity with all these discussions.
Well, I think it really isn't that clear because it's still happening. So it's not the result that I'm hoping for, because it's going ahead with them widening. If it was just the widening of the garage, of the driveway, that's one thing, but it's leading to something else.
But at this point, they are here for just
the widening of the driveway. I understand that, sir, but I could see down the road what their proposed work is specified here. Because they could use the garage, knowing that they want the space. It's leading to what they've approved for the conversion of the garage.
They can't do by themselves, obviously. They have to come through it. But if you find any activity and if you're concerned in the future, you're more than welcome to contact the City of Brampton or the bylaw department.
Once the garage is gone, right? Once the work is done and the garage is renovated, the home will already be modified. Is that not correct?
I guess maybe. Okay. Okay, Mr. Bauer. Yeah.
Through you, Mr. Chair. Could we add a recommendation to say that the garage cannot be used as a third dwelling to maybe satisfy
Concerned neighbor?
Through you, Mr. Chair, that's certainly a condition that can be imposed. That goes without saying. However, it's simply not permitted to be a three-unit dwelling. And again, through you, I believe part of the homeowner's concern is that she's concerned that both units will be rented out, and that conversion of the garage will create a larger second unit, which may be able to accommodate more people potentially. But it is part of the principal unit. I note that many of the homes in this area don't have a garage in the first place.
Exactly.
Some of them have carports. Some of them don't have anywhere to park vehicles for shelter. They're simply parked on the driveway, which is obviously permitted. There is no requirement in the zoning bylaw that a garage be maintained or that there be an area that's available for a vehicle to be parked indoors. So this is simply the conversion of a garage, which if it wasn't for a secondary, if it wasn't for the fact that there's a second unit in this property, could be converted without any further approvals.
Exactly.
All they would have required was a building permit.
Yeah.
The only reason we're here today is because there is a legal second unit and they're looking to accommodate that third parking space. But the city has no authority to dictate who resides in or whether a homeowner can rent out both of the legal units that they have created with permits and approvals.
Just one question. Is this prudent for us to add that there's not third dwelling unit? Something, can we add? If it's not appropriate, please recommend us, because we are talking in circles and we need to move forward.
I wouldn't be opposed to that condition. It's certainly something that can be enforced by staff.
Okay, so if you can please suggest some wording, Ms. Corzola?
So my recommendation for wording for your consideration would be that the conversion of the garage shall not be for the purpose of facilitating the creation of a third dwelling unit.
Okay, and ma'am, if you can please step back a little, I would like to talk to the agent. So do you understand and accept this condition?
Yes, we do accept this condition, and in our drawing it clearly states that the conversion of a garage is not for the third dwelling unit.
We fully understand.
It is for the principal residence.
Yeah, no, we fully understand that part. So right now, we have 4 conditions in total.
Correct.
Okay. Ma'am, I hope we answered all your questions, and with all the discussions, I hope but we fully sympathize with your concerns, and we understand what the neighborhood, what could be the impact on the neighborhood if something is obviously going over the codes and the bylaws. Okay, so I guess we hear all the parties, and this is where the committee is. For any application, as I discussed earlier, we have 20-day appeal period in order if anyone who wishes to appeal to the next level, which is LPAT, and can contact Secretary Treasurer within 20 days appeal period. Okay?
Thank you.
Okay, welcome. If no further discussion, looking for a motion to proceed.
Motion to proceed with staff's 4 recommendations.
Motion to proceed with the staff's amended recommendation by Mr. Power, seconded by Ms. Marcus. All in favor? Approved.
Thank you.
Thank you.
Calling application E19-176 GC Jane Investments Limited. The property is located at 7875 Mayfield Road.
Good morning. My name is Ali Shafai, principal of A&O Associates Architect, representing the owner. Our application, we are working on the Jain Temple in the mentioned address. We are applying for increasing the GFA by 260 square meter in second floor of the temple.
Okay. Committee members, any question, comment, concerns? No other concerns? Anyone in the audience wishes to speak on this application? Seeing none, staff, could you please weigh in your comments?
Yes, through you, Mr. Chairman. It's noted that the official plan, secondary plan do permit the proposed uses on the property, and that when the zoning was first put out, it permitted only 929 square meters for the place of worship. Back in 2012, variance was requested to expand that from 929 to 1393 square meters. And now we're here today to expand it a little bit further by another 260 meters to allow for now 1,620, approximately 5 square meters. Staff was initially concerned for reasons of parking and that this would be used for additional prayer area. Well on site, though, I've spoken with the contractor, and it was indicated that one of the concerns I had was that there'd be no windows or openings looking down from the second floor loft down into that. They could expand out and make it into a prayer area expansion. And that was not the case. There will be no openings. This addition on the second floor is nothing more than a second-story mezzanine, which will have steps leading to it, and nothing further than that. And for that reason, staff are able to support the requested variances subject to the following conditions. First, that an amendment to the site plan approval for this project, being SP 10-011-001, shall be obtained within 120 days of the decision of approval to facilitate the proposed changes to the approved elevation drawings, or as extended at the discretion of the Director of Development Services upon receipt of a written request for a time extension from the owner, if that time can't be achieved. Second, that a building permit shall be obtained within 90 days of the decision of approval for the second floor storage area and the new exterior staircase. Third, that the extent of the variances be limited to that shown on the sketch attached to the public notice. And fourth, that failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Okay. Sir, do you understand and accept these
Fully, sure.
recommendations?
Yes.
Okay, if no further discussion, looking for a motion to proceed. Motion to proceed with staff recommendation by Mr. Power, seconded by Ms. Marcus. All in favor? Sorry.
Through you, Mr. Chairman, sorry, a little dialogue between ourselves here. Just because visually when I was there, partial construction was underway and I could not see the complete version, maybe there would be some appropriateness to have a fifth condition that sort of speaks to the fact that there is no windows or openings involved, so we can't hypothesize whether there could be. So maybe we would add a fifth condition that there shall be no openings or interconnection between the storage mezzanine and the worship area below. I'll give that to you, Jeannie, later if you need to. I'm not that fast of a writer.
So do we need to open again, or we can just put another motion? Sorry?
Through the chair, the motion had not carried at the time that staff interjected.
Okay, so, sir, there's one more condition has been added, so I hope you're fine with it.
Yes.
Okay, so looking for a motion for amended 5 recommendations by Mr. Power, seconded by Ms. Marcus. All in favor?
Thank you.
Thank you. We were trying to catch up your speed, Mr. Nick reports.
Calling application A19-177, Brian Chan. The property is located at 60 Victoria Street.
Sir, please go ahead.
Good morning. Don Arthur, agent for the owner, Brian Chan, 60 Victoria Street. We're seeking relief from the zoning bylaw for a front yard location of an accessory shed.
Okay. And you're permit an accessory structure.
Sorry?
You're here for 60 Victoria
Yes.
Street, right? Okay. Committee members, any question, comment, concern at this point? Seeing none. Anyone in the audience wishes to speak on this application? Seeing none. Staff, could you please weigh in your comments?
Yes, Mr. Chairman. This property is designated village residential in the city's official plan and Churchville Heritage Conservation District in the Bram-West Secondary Plan. As such, the site is designated heritage resources under Part 4 of the Ontario Heritage Act. The requested variances do not have any impact on the other official plan policies. Through the zoning, we've deemed that the property fronts onto Victoria Street, even though there could be some discussion as to whether it's also on the other side street, Adelaide, which is the gravel road that leads up to the property. The property here consists of 3 separate parcels. Just to keep things simple, we're going to say that the Victoria Street is the front, and they're proposing to put the accessory structure in the front yard in the middle property. Typically, staff would not want to see that, given that from a streetscape perspective, that could be problematic to the adjacent residents. This, again, is a unique property, tucked far away and not traversed and very easily visible given the landscaping in the area. Staff would not have a concern in this particular situation allowing the accessory structure in the front yard, subject to the conditions being proposed. And those conditions would be that condition number 1, that the applicant acknowledges and agrees that the proposed accessory structure shall be designed and constructed and shall not exceed the zoning bylaws gross floor area and height requirements. There was some question as to maybe there might be a few square feet over. To be 100% sure, that condition's there to make sure that when we look at this from the building point of view, we've captured that. Second condition, that the new accessory building be constructed in general accordance with the proposed plan and drawings dated June 7, 2019, prepared and submitted by the applicant in support of the minor variance application. Third, that the extent of the variances be limited to that shown on the sketch attached to the public notice. And fourth, that failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Okay, for the record, I'd like to include a letter from Credit Valley Conservation Authority stating no concern and no objection. So do you understand and accept these recommendations?
Yes, we do.
Okay, if no further discussion, looking for a motion to proceed. Motion to approve by Mr. Power with staff recommendations. Seconded by Ms. Marcus. All in favor? It's approved. Thank you.
Thank you.
Calling application A19 178 under the name of Ramsamy. The property is located at 18 Agricola Road.
Hello, my name is Jivtesh Bela. First name is Jivtesh, last name is Bela. I'll be authorized agent for 18 Agricola owners, Mr. and Mrs. Ramsamy. And our minor variance application, basically we applied for number 1 variance application to allow a below grade entrance on the exterior side yard. Oh, sorry, I was just listening on my own voice here, so I thought I'm speaking louder. So I'll let the staff members comment on the application, then I'll have my own comments later on.
Okay, committee members, any question, comment, concern at this point? Saying none. Anyone in the audience wishes to speak on this application? Saying none. Staff, could you please weigh in your comments?
Yes, Mr. Chairman. There's 3 variances being requested. One, the primary one really coming forth is that to allow for an exterior stairway leading to a below-grade entrance in the flankage lot line. I was of a little bit of mixed opinions when I looked at this. I could see that through another example just around the corner that the applicant was able to take me to and says, look, in this situation, from a streetscape point of view, it's the view of the stairway leading to the basement is minimized, which it was, and this was through another minor variance. And so after doing a little bit of further research and understanding, planning staff have been consistently recommending refusal of these applications, given that we're trying to maintain a streetscape appearance, and we can't always guarantee that the resident is going to provide appropriate landscaping in the front to screen these types of below-grade entrances. The applicant was good enough to provide me another example where staff actually did support this a couple of years ago, but it's a little bit different where you have a veranda and every site's going to be a little different from a visibility point of view. So in the end, to be consistent with the other staff reports, I did recommend refusal of the request for the stairwell leading to the basement. As a result of the request to want to do this, when staff were on site, we did notice that the shed was in the exterior side yard, which is not permitted, and that same shed is located 0.28 meters to the side, or the exterior side property line, whereas it should be 0.6 meters setback. So staff is supportive of the latter variances to the exterior side yard, given that there is fencing in the back. It's reasonably well screened.
Sorry to interrupt you. I think it should say supportable in part, not supportable, I guess, in your staff report. At the first line of the recommendation, that application A19-178 is supportable in part because you're recommending refusal for the first variance.
That's correct. I was speaking more so just to the shed permissions that
no,
were
no problem. Please,
but you're right. Approval in proportion, subject to the following conditions, and that would therefore be the first condition is that the variance first one to permit a below-grade entrance in the exterior side yard be refused. Secondly, that the applicant obtains approval from the manager of development engineering to provide a drainage design that ensures that roof drainage from the accessory structure, being the shed, is contained within the subject property and does not impact the adjacent lands within 60 days of the decision of approval. Third, that the extent of the variances be limited to that shown on the sketch attached to the public notice. And fourth, that failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Okay, thank you. So do you understand and accept these conditions?
I would like to comment further on variance number one. I'm going to give you an example on this is the example that the staff was talking about in his comments where the similar below-grade entrance was approved for this particular house, and this is the exact same model built by Madme Homes, and this is a very common model that they have on the corner lots. And if you look at our site plan here, like this model doesn't allow us to put a below-grade entrance anywhere else at the property, because if you look at the side yard, we don't have enough setbacks on this side to allow a below-grade entrance. And if you want to do in the rear yard, we actually have to dig a tunnel through the garage leading to the basement, which is not feasible on this house. So two years later, like 2 years ago, we did another minor variance application in 2017. That was for 1 Stead Street, which was right inside the porch, where I took some pictures for this address as well, to show you that the below-grade entrance was actually right inside the porch, where it doesn't really affect the view from outside. And this was another picture from the side yard here that if you can see, there's a below-grade entrance, but it is totally hidden inside the porch. So this particular model doesn't allow us to do below-grade entrance anywhere else on the house. So my request would be to allow the application so that the client can go ahead and do the below-grade entrance on this property.
For you, Mr. Chair, could you put back that picture for 20 Aylesbury there, please?
Yes.
I wasn't party to the other ones that were approved prior, but I was with this 20 Aylesbury, and we put in a number of conditions for Aylesbury. If you take a look at that, although it's done tactfully and nice, the homeowner still, as of past Sunday, of Aylesbury still hasn't complied to the recommendations of the staff. So if you look there, the downstairs, they've got a railing going across that basement window, right? That's a fire code.
Right? So
And then furthermore, they were to change the driveway. They haven't done that as well, right? So the challenge is that these types of things keep coming forward, right? We put in recommendations to be supportive of citizens of Brampton, but then 90 days later, they haven't complied. Does that make sense?
Yep, completely agree with you, Mr. Power. If something, even this committee, another application granted, obviously that time, some different circumstances, different situation.
Yep.
Not necessary that if somebody else got some sort of leniency from this committee, then we'll keep following that. Each and every application is different. That's how we look at it.
Okay, yeah.
Regardless of its a corner situation or the same model. But I appreciate that you're bringing this, example in front of us. I was there at my site visit, and I noticed, and I understand, and I fully sympathize that they don't have this other side. The space is less in order for them to put together entrance. They cannot do it. Yeah. But this is something, it's not that they got shocked about it. They purchased this, right? The homeowner at that time, they knew that what they are buying. And what is allowed and what is not. And I know you're in front of us, like full respect to you as you're doing your job, and they're in good hands, and you're presenting a good scenario in front of us. And thank you for doing it and bringing this information. But to echo Mr. Powers' comments, even if somebody else got, and they still need to go through a bunch of conditions got added at that time, and if they have not fulfilled those conditions till, and I guess staff or our bylaw officers will be following into that one. But I simply, at this point, I'm not in agreement with granting this underground, step-down staircase, and I do staircase entrance for the basement, and I do agree staff report. Please go ahead.
Sorry, just want to give you another example on Wanstead. Like, we can also do something like this, where the below-grade entrance are right enclosed inside the porch. And this application, similar application, was also approved in 2017, and we did that application for this property as well. So we could propose something like this. So I revised my site plan stating that the below-grade entrance can be proposed right inside the porch. So for this, there wouldn't be much landscaping that would be required in order to get these stairs for this house. Because to be honest, we don't have any other option on this model at all.
Well, if you wishes to modify your application, obviously that has to be, you need to provide, like, to show us here is different thing, but we cannot make decision.
Yep.
What I can suggest to you, and obviously committee members can advise me on that, if you are willing to go ahead with this current application, as you mentioned, and staff already looked all those aspects at present what you're requesting on behalf of your client. I guess right now what I see, we are not in agreement, so we need to move forward in that application. However, if you're willing to modify your application, that's a completely new application.
Okay.
You need to provide all the supporting papers, so staff can look back at. What I can do, or what I can suggest to my committee members, if you want to modify your application, then you need to request for a deferral, and then you can come back in the future date, and then, so meantime, staff can look whatever they need to do their due diligence, and then they can prepare a new staff report, and then I think we should be able to comment on this, your new provision, if you feel you can achieve something by making some changes to your application.
Sure, I will go, like, I would request to defer this application for the next hearing date, then we will revise your site.
I don't think so. You will be able to do anything in the next hearing date because you are modifying your application.
Okay.
So maybe you're looking at December's application, December the 3rd, and the submission day will be November the 5th. I think my memory is getting better on this committee. So November the 5th is the last submission day for December 3rd application.
Okay, I think we will be able to meet that deadline. We already have revised site plans ready to go, and we will talk with the staff members and
Okay, that'll be great. So I guess staff is okay with that? Okay? So if no further discussion, looking for a motion to defer for December the 5th by Mr. Power, seconded by Ms. Marcus. All in favor? Thank you.
Calling application A19-179, Harjit Singh and Harminder Kaur. The property is located at 37 Foxtail Crescent.
Hi, my name is Jiftesh Bela again from Noble Elite Solutions, authorized agent for Harjit Singh and Harminder Kaur for 37 Foxtail Crescent. And that's it. And I'll wait for the staff member comments and then I'll
Sure.
put in mine.
Committee members, any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Seeing none, staff, could you please weigh in your comments?
Yes, through you, Mr. Chairman. The applicant is proposing an as-built above-grade side door. There's a couple places deep in the report where I made reference to below-grade, but it's an above-grade side door, and it's not below-grade. It's just pretty much flush, with the exception maybe about a few inches above grade. And they're also looking towards widening the driveway in addition. And there's also a shed in the rear yard that's a little closer to the side property line than what is permitted. So, I'm just looking for a picture. Staff are supportive in part of these applications, subject to the following conditions. That within, first condition, that within 6 months from the date of the committee's decision, the applicant shall make arrangements satisfactory to the Director of Development Services to demonstrate that the shed has been relocated and is no closer than 0.6 meters to any property boundary. Our engineering section has determined that it will need to be relocated to avoid any drainage problems. Second condition, that the below-grade entrance shall not be used to accommodate an unregistered second unit. Hence, it's above grade. So, should be noted that there. Above grade. Entrance shall not be used to access an unregistered second unit. Third, that the variance number 3 to permit the driveway widening be refused. Therefore, within 6 months of the date of the committee's decision, the applicant shall make arrangements satisfactory to the Director of Development Services to demonstrate that the paving stones have been removed on the west side of the driveway and reinstated this area with some form of soft landscaping, that being grass. Fourth, that the extent of the variances be limited to that shown on the sketch attached to the public notice. And fifth, that the failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Just a comment to Mr. Spilla. I know you work and you come with the committees. Just advise your clients to give us the access to the backyard. I'm not saying that you didn't, because Mr. Power was there and myself. We tried to get to the backyard because of requested variance. We were not able to get. I knocked on the door a few times and no one answered. But Ms. Marcus got the access, so we are fine. We are proceeding with the application, but I'm not saying like you're not doing, but sometimes the homeowner just think, yeah, maybe they come or not. Just give them a heads up next time.
Yes, Mr. Chair, I will give them heads up for next time.
So, about these recommendations, do you understand and accept? But before I go to you, Ms. Corzola, please.
Thank you, through you, Mr. Chair. I have one requested amendment to condition number 2. In as much, I do want to make it clear that the and I guess it's an at-grade entrance, shall not be used to access either a registered or unregistered second unit. they do not provide the clear 1.2 meter path of travel that would allow for this entrance to qualify as a secondary entrance or a principal entrance to a secondary unit.
But this is a below-grade entrance, it's not at grade.
This is above grade.
Sorry? No.
Here's a copy of the photo. So it's just a little step up above grade there.
Oh, yes, yes, yes. I actually mistake with another property. But yeah, this is at grade. Yes. And the path of travel is not that much, it's just close to.
It's very close. It's
Yeah.
still a 1 meter setback, but it fails to meet the
Yeah.
1.2. So I just want to ensure that it's neither an access to a registered or unregistered second unit.
Okay, so that amendment is good. Thank you for doing that, Ms. Corzola. Sir, back to you.
Yeah. So yeah, we do accept those conditions, like the amended condition as well. City of Brampton Building Division doesn't allow any, like they don't accept any building permit applications if it's less than 4 feet anyways through that door. So we will accept those conditions and the amended conditions as well.
Okay, with the driveway widening and everything, they need to bring it back?
Yeah, we
because-
would have ideally, we wanted to get it approved,
Yeah.
if I did talk to the staff member, and then that would not be supported, so I'm not
Yeah.
going to comment on it.
Okay, sorry, please go ahead.
Through you, Mr. Chair, just to be consistent with an amendment you made to a previous recommendation where not all of the variances were supported, I would just make the recommendation that application.
Supportable in part?
Yes.
Okay, so, well, that's understood if we are, normally it says supportable in part, because when it says supportable in part, when I read these staff recommendations, I read more carefully. When it says supportable, so I just keep going in the flow. So that's just for my personal comfort. So, Ms. Marcus?
I suggest that we approve the application as per the staff recommendations and amended recommendations.
So motion put forward by Ms. Marcus with amended recommendations by staff and seconded by Mr. Power. All in favor? Approved.
Thank you. Thank you, members. Thank you, committee. Thanks.
Calling application 19180, Thomas and Anna Lamb. Property is located at 28 Piccadilly Place.
Good morning.
Good morning, Chair and committee members. My name is John Carlotari. I'm the active agent on behalf of the Lamb residents. And today we're here for minor variance for rear yard setbacks. And specifically want to note item 4 about the driveway widening. And we are in acceptance for the staff report.
Sure. You are in acceptance of staff report?
Yes, we are.
Okay. Any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Seeing none, staff, could you please weigh in your comments?
Yes, Mr. Chairman. In addition, there's a requirement with, okay, so the applicant is proposing a second floor shed and, not shed, a porch and a walkout in the rear yard, and the additional GFA is going to also require a variance to the overall, where is it here? To the overall floor area. Go from 30% up to 32.7%. So that's an additional variance being requested. There's a total of 5 variances. So as a result of the primary being to do the work in the backyard, we also noticed that the driveway in the front yard was widened beyond what it should be, and that there was also the driveway closest to the intersection was set back 2.48 meters from the projected point of intersection of the 2 streets, whereas the bylaw requires 3 meters. And that is for safety purposes, to make sure that when your car does pull up, you have sufficient area to look around, and that there's no tall landscaping and or physical structures in the way. So staff are not able to support the walkway extension that would impede on the 3 meters. Staff would be willing as a bit of a compromise to allow the driveway to be widened, but only within 3 meters of the dwelling, at which point thereafter, as it moves away from the dwelling, you then reinstate soft landscaping in that location. So staff is supportable of some of the variances, and so in part is supportable, subject to the following conditions being proposed. That variance number 4 be refused, and that would be for the driveway to project into the required 3-meter extension of the intersection. Second condition, that within 9 months of the date of the committee's decision, the applicant shall make arrangements satisfactory to the Director of Development Services to demonstrate that the 1.3-meter wide strip of paving stones located on the right side of the driveway and beyond 3 meters from the front face of the garage has been removed, and that this area has been reinstated with soft landscaping, that being grass. Third, that the extent of the variances be limited to that shown on the sketch attached to the public notice. And fourth, that failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Okay, sorry, you already said that you understand and accept these conditions?
Yes.
If no further discussion, looking for a motion to proceed. Motion to approve with staff recommendation by Ms. Marcus, seconded by Mr. Power. All in favor? Approved. Thank you.
Thank you, committee members.
Calling application A19-181.
Andrew Jane. The property is located at 167 Buford Drive.
Good morning. I'm Anju Jain, and I'm the property owner for 167 Buffer Drive. Actually, I had applied for a below-grade entrance from the interior side yard because I want to do the second unit in my basement.
Okay. Thank you. No further comments, committee members? That's what I hear. Anyone in the audience wishes to speak on this application? Staff, could you please weigh in your comments?
Yes, Mr. Chairman. Staff are supportive of the requested variances for the proposed below-grade entrance, subject to the following 4 conditions: that the applicant obtains approval from the Public Works and Engineering for a side yard drainage design that ensures that the drainage from the applicant's side yard follows the approved drainage design for the property and is contained within the subject property and does not impact the adjacent lands. Second, that the below-grade entrance shall not be used to access an unregistered second unit. Third, that the extent of the variances be limited to that shown on the sketch attached to the public notice. And fourth, that failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Do you understand and accept these conditions?
Yes, I do.
We have no further discussion. Looking for a motion. Motion to proceed with staff recommendation by Mr. Power, seconded by Ms. Marcus. All in favor? This is approved. Thank you.
Thank you.
Calling application A19-182, Masco Developments Limited. The property is located at 67 Selby Road.
Hello, good morning, Mr. Chair and committee members and staff. Thank you so much for having me. I'm Nicole Rugano, representing as the agent for 67 Selby Road. As you are aware of the number of variances we've requested, we've been working with city staff. We went over the staff report, and we have no objections to any of the conditions, so just here to answer or clarify any questions or comments.
We always like those applicants. They don't object to staff report.
Of the conditions, sorry.
So I guess no question, comment at this point. Anyone in the audience wish to speak on this application? Seeing none. Staff, could you please weigh in your comments?
Yes, through you, Mr. Chair. There is a site plan application associated, and the applicant has submitted and obtained approval of a parking study. So this application is supportable subject to the following conditions. Number one, the extent of the variances be limited to that shown on the sketch attached to the public notice. Number two, I'd like to note that there is a minor change. So the variance number one, the only associated with the proposed use of the building being a cannabis production facility instead of growing facility. Number three, that the owner finalized site plan approval under City File SP 19-011, execute a site plan agreement and post any required financial securities and insurance to the satisfaction of the Director of Development Services. And four, that failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Good to go.
Okay. So if no further discussion, looking for a motion to proceed. Motion to approve staff's recommendation by Ms. Marcus. Seconded by Ms. Bauer. All in favor?
Thank you.
Thank you.
Calling application A19-183, PD Commercial Mayfield Road, Inc. The property is located at the southwest corner of Mayfield Road and Credit View Road.
Good morning, Mr. Chair and committee members. For the record, my name is Mark Candello of Glenn Schnarr & Associates, agent representing the applicant, PD Commercial Mayfield Road, Inc., owners of 1455, 1465, and 1475 Mayfield Road, located at the southwest corner of Mayfield Road and Credit View Road. I'm here to speak to you with regards to minor variance application A19-183. A little bit of context to why we're here today. The applicant is proposing to develop the site for a commercial development that is in keeping with both the official plan and the Mount Pleasant secondary plan. The property is subject to an active site plan application and is currently with the city staff for review. We are advancing the site plan application with city staff, and discussions on the application have been positive, which has led us here today. Through the site plan review, city staff have identified a number of variances that would be required to facilitate the proposal, and I can take the committee through those variances. Variance 1, the applicant is seeking to permit the use of a supermarket on the property where the bylaw does not permit the use. Just to provide a bit of context on that, the zoning for the site allows a convenience stores among other commercial use. The zoning bylaw defines a convenience store as a retail establishment engaged in the business of selling groceries, meat, fruits, and vegetables to the general public and occupying a premise of having a gross commercial floor area of less than 600 square meters. Any floor area that exceeds 600 square meters is then considered a supermarket under the bylaw. There's no difference in function in how a supermarket and a convenience store function in the bylaw and how it's defined, except for a variation in permitted gross floor area. The variance is seeking to permit a tenant to allow a gross floor area of 944 square meters, and that's on building C of the site plan. Variance 2 requests a parking variance or parking reduction. Based on the total gross floor area of the proposed development, the bylaw requires 108 parking spaces. Through the application, we are requesting 98. The site plan technically can support 100 spaces, but at the request of city planning staff, 2 spaces have been put aside for potential cart carols and just to have that flexibility for the potential grocer. Variance 3 to request a reduction in the drive-through car stacking. For a restaurant drive-through, the zoning bylaw requires 10 spaces. Through the application, 7 are being proposed. With regards to variance 2 and 3, BA Group was retained to provide an analysis in support of the variances. Their study found that the variances can be supported and that there would be no adverse impacts on the surrounding network. And variance 4 requests a setback to a reduction of a site daylight triangle. The bylaw requires a 3-meter setback to the site triangle at the intersection of Mayfield Road and Credit View Road. Through their application, we're proposing 1.5 meters. As noted in the staff report, city's transportation staff have noted no concerns with the reduction, and the proposal would bring the building closer to the intersection to create a more active streetscape along Credit View and Mayfield Road. I'll speak to the staff report once city staff had a chance to review, present their comments and conditions.
Okay, sure. Board members, any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Seeing none, staff, could you please weigh in your comments?
Yes, Mr. Chairman, I concur with what the applicant has stated. They've gone through pretty much the content that was in the staff report. The only concern that staff would have had was the building proximity at the intersection going from 3 meters down to the 1.5 meters. As was noted in the report and by the applicant, our transportation section did not have a concern. It is not for the entirety of the triangle. It's only for a small little portion of it. As such, staff are supportive of the requested variances subject to the following 2 conditions. The first being that the extent of the variances be limited to that shown on the sketch attached to the public notice. And secondly, that failure to comply and maintain the conditions of committee shall render the approval null and void. So those are the 2 conditions. Again, the first condition, and I guess the associated second condition, is really related to the proximity of the building at the intersection, only one small portion. If it was the entirety of it, I'm not sure if the transportation section would have changed your comments or not, but I don't know that since that wasn't put to them. So we'll leave it at the way it is.
Okay. You understand and accept, staff?
We do, and we accept the conditions.
Okay, if no further discussion, looking for a motion to proceed. Motion to approve staff recommendation by Mr. Power, seconded by Ms. Marcus. All in favor?
Thank you.
Thank you.
Calling application E19-145, 219-7008 Ontario Inc., and the property is located at 3 Edvac Drive.
Morning, Mr. Chairman.
Morning.
Rest of the council. My name is Brian Roseball. I'm representing Ocean Jewel Export Packers, who is the owner and operator regulated seafood distribution facility here for decades in the city of Brampton. The owner, Jeff Rubenstein, he's right behind me, so I'll speak to this, but he'll also have a couple things to say about this as well. So we've been discussing the lot extension on the site for 2 to 3 years through pre-consults all the way through the application for site plan application. With the city of Brampton Planning Department, it's been, we've been dealing with a couple people. There's been some change in staff, but we've been working through the team and been collaborating on a solution. There's 3 main variances here on this site. I'm going to jump over to just number 2 and 3 because they're pretty straightforward, and we're in agreement with the recommendations that are set out here, which were laid out in regards to reducing the depth of the parking and also the distance of the parking from one another. This is somewhat grandfathered. It was already there on site, and we weren't touching this at all, but we're in agreement with what's been recommended. Predominantly, we're here about variance number 1, which has to do with the lot extension. This building is located Humber West Parkway and Williams Parkway, and ultimately, we're asking for, out of this 12-meter setback, we're asking to have that reduced to approximately 4.4 meters. And the purpose of this has predominantly to do with the function of the site, it being a distribution facility and with loading docks, the necessity to have trucks in the swept path to work as the company, and the industry has really evolved to larger trucks. This is something that is required. And through the truck swept path analysis that we've submitted, it shows that in order to fit these, to prevent some of the damage, some of the safety concerns on the site, to allow for the truck path to meet the function of the site. So we understand the aesthetic, the importance of the aesthetics, especially on Humber West Parkway. There's been proposals. We have 2 separate landscape architects propose to meet and exceed the requirements for the number of trees, types of trees. We've proposed to address potentially the aesthetics of any sort of proposed building addition, which is a side point to the lot extension. We've also proposed even whether it's other types of screening, whether it's continuing the retaining wall that's currently on Humber West Crescent, or maybe a high screen. Really, it's more about the function of the business. In order for them to thrive here in Brampton, they need to have this done. And we're really, willing and able, Jeff will speak to this, really willing and able to work on the aesthetics in any way possible. But this is really something needed for him and his business, being a distribution facility. At this time, I'll let you guys speak, and maybe Jeff can come up afterwards to say a few things. Do you want him to do that now, or maybe hear what you guys have to say?
Maybe you want to hear the city staff first, and then?
Yeah, let's do that, yeah.
Sure. Committee members, any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Seeing none, staff, could you please begin your comments?
Thank you, and through the chair. First of all, to read through the conditions. Recommendation is that application A19-145 be approved in part, subject to the following conditions being imposed. One, so that variance 1 be refused. 2, that the parking stalls of reduced depth be signed for small car parking only. 3, that the extent of variances 2 and 3 be limited to that shown on the sketch attached. And 4, that failure to comply with and maintain the conditions of the committee shall render the approval null and void. And just as a brief discussion on the city's opinion with respect to variance 1, the intent of requiring that 12-meter landscape buffer along Humber West Parkway, not just on this property, but along the industrial area of Humber West Parkway and along Williams Parkway near the intersection as well. It appears that when this area was originally planned quite a number of years ago, it was recognized that this is a main gateway to the large residential neighborhoods that are further to the north. Humber West Parkway, being a major arterial road, is going to see a lot of traffic, commuters, regular traffic, with the majority of them being those residents to the north. And it was looked at that as a result of those patterns being residents having to drive past these industrial buildings, especially on their way to get to the highway, to get to work, etc., that an upscale landscaping treatment should be provided for them, and especially considering there is that more of a landscaped type area on the other side of Humber West Parkway. It makes this more of that kind of nice parkway feel. 12 meters was decided because that essentially enables to have a double row of trees be planted within the buffer, and then to have some other type of ornamental landscaping that could be provided to kind of fill in the gaps between the different trees. The proposal for 4.43 meters just simply doesn't allow that level of upscale landscaping that was expected when the site-specific zoning was passed here and in the area. We, as I'm sure the committee can remember, we've deferred this a few times now to try and work with the applicant to see if there's any possibility to figure out how to change the way the site is laid out to get more landscaping space. Through those discussions, we weren't really able to come to a compromise, which is why we've come back today with a recommendation of refusal for that variance 1.
Okay, thank you. It's your time to respond.
Yeah. First off, and I know verbally over the phone, there's maybe a willingness to bend a bit on the refusal beyond. Just saying, verbally, there has been a willingness to bend on the complete refusal of this. We know the adjacent lot has their lot extended about 15 feet beyond where the current set is right now. We also know that the number of trees that are set out here, again, we're going to be exceeding the number of trees that are there now, but there are, if you look on Google Maps even, you'll see any of the adjacent units have half, a quarter of the number of trees that are set out. If you look at any of the renderings that we've provided for you guys, you'll see there's really little impact aesthetically that you guys would be seeing. On the north side of Humber West, there's no residents that are directly across. You'd have to go quite distant. So there's no visually, you won't be seeing that. Maybe on their drive to the highway, potentially that'd be the case. But ultimately, again, this is about a function for the business to thrive here in Brampton. This is what's needed. We're willing to work with the aesthetics. We've also brought in, like I mentioned, any sort of other type of screening we're willing to do that.
Two things. I have the picture in front of me, the next door neighbor and your property. They don't have the docks, I guess, the way you have in this property. So even though they are a bit more closer to the road, but their situation is different in terms of what it's going to be used. I personally feel I think by looking at your proposal, we are going to compromise too close to the road. That's what my understanding is. I can clearly see the next door property, and I visited myself. Their look towards Humber West is completely different than what your property is putting together.
The look or the function?
The functions and the look both, right? So even if they have a bit more close to the road, the use is not as it's going to be yours, right? And I don't know much details about the next door property, but that's my observation, right? Mr. Power?
Through you, Mr. Chair. You had mentioned that you recently just started communication with the city where you can maybe come to a compromise, or no?
I'll answer and then. We have been in discussions throughout this whole process from the first time that this variance was submitted up until now. It was described then and continues to be said now that we do have some flexibility here. I mean, of course, we're understanding that it's difficult with the current layout of the site.
Yeah.
And essentially we said, what you're proposing now, going down to 4.43 meters, is too much of a reduction for us to be able to be comfortable with that. And so we asked for a number of different studies, including the truck swept path analysis. After we received that and we looked at it, said, okay, as a result of looking at this, perhaps more work is going to have to be done to be able to accommodate this type of an expansion. And at that time, that was where we essentially reached our impasse, that it was our position that this is going to be a bit more of a comprehensive of a development of the site to enable development that we're both going to be satisfied with. And my understanding was that the applicant was not necessarily willing to go down that path. They wanted to stick with what they had here, so that's why we're here today with the recommendation of refusal for variance 1.
I understand, but I'm sure they're not up to where this applicant is requesting, but I'm sure we have some sort of flexibility to accommodate if they come back with something. At least I would say 4, 5, 6 feet. I know it's hard for you to comment on that at this point, but I can see the way it's proposed being turns and stuff. I think that's a big compromise and too close to the road.
To have it up to the 4.4 is too close to the road.
Yeah.
Yeah.
Could I just speak for a
Sure,
second?
sir. Your name
I've never done this, so.
No, that's okay. Don't worry. Your name and address.
My name is Jeff Rubenstein. I'm the CEO of Export Packers. And we've been in Brampton for, I'm going to guess, 40, 50 years.
Way over my age.
Sorry, when Bill Davis was
Premier, Honorable Bill Davis.
So anyway, we're a seafood company, and in this particular building, we run through 200,000 pounds of fresh seafood a week. Back 10, 15 years ago, trailers would come in. All this product comes from, it's all flown in fresh, goes into Miami, it's brought up by truck. And 15 years ago, what we had was 40-foot trailers. Today, everything's changed to 53-footers.
Yeah.
So the problem today is that our depth that we have in our lot, the drivers can't back in because the trailer is so much bigger. And to be honest, the drivers are not as proficient as they were 15 years ago. They can drive, from A to Z straight, but when they got to turn, it's a different ballgame. So we just inked a deal where we're going to bring in super frozen. I said we're a fresh company. We're going to bring in super frozen tuna at minus 60 degrees. So we need this expansion to house this special process. So what, I actually went out there the other day and took a picture. Forget about the Liberal who was running, okay? But I took a picture. This is my lot over here. This is the lot beside us. And there's a retaining wall that runs all the way down the street, this retaining wall. So I said to my people, I don't do this for a living, is why don't we offer to continue this retaining wall? If there's a concern about aesthetics, I'm happy to continue the wall all the way through, and then move the trees back closer to the wall, which I think the number is like we're talking about 4.4 meters from the lot, maybe it's 6. But this way, you can see it this way. This wall will be extended all the way down. Aesthetically,
can you please have a look at that picture, please?
You want to see this?
Yeah. If you,
oh, I told you I've never been here. So you can, that's pretty cool. I got to get that from my office. So where that sign ends is roughly where our lot starts. So I'm proposing, if it works, to extend I assume that wall was built by the city of Brampton. I wouldn't think it was built by individual, because it runs all the way down.
maybe region or city, we can obviously look into.
Yeah, we can find out, but I'm happy to pay or build it myself all the way down, so aesthetically, without the Liberal signs now, we don't need them there now.
But the guy got the election last night. Maybe you can congratulate him when you see him next time.
Anyway, so I'm prepared to do that. And the other thing is this, the whole argument of aesthetics is somebody driving by is concerned about what they're going to see. Well, we said we would build through two arborist applications, dense trees to block out what our side is showing, which is basically trucks backing into a dock. So this is the other one, looking the other way. So that's our lot where I'm actually standing. So I think, if the committee can at least see, we can't back these trucks in under certain circumstances. And by the way, we're going to be hiring at least 10 to 15 more people in the Super Frozen program. And we supply all the retailers, all the food service, fresh fish is flown in from all over the world. So I'm pleading with the committee that we need this extension to get, it's only because of the trucks. If the trucks were 40 foot, we wouldn't be here. But they're not anymore, they're 53 feet. So this is the situation that we're in.
So at present, those trucks cannot back up to your dock?
Sorry, you have to talk a lot.
At present, right now, the 53 feet trailer.
They can get in there now, very difficult. So what we're proposing to do is take out a door. So that door, when we take out that door, there's less space to back in. And not only that, the extension that we're going to put in is going to have underground cable to heat it, because in this winter, if we have a major snowstorm, where do we put the snow? Because it'll just be piled up and they won't be able to back in. So we're going to put in underground cables to make sure that there's no snow buildup. But right now, if I put that, we have a CAT program that shows, a computer program that shows that they can't back in. It shows it. Yeah, so what I'm talking about, the trucks come along here, and they come over here, and they do a bunch of turns, and get over to here, and then back in. So this door here, the one we're going to be taking out to expand the plant here. So we have less room to back, so we need this space back here.
So here's my question to the staff. In this proposed, I can see they are pretty much leveling with the next door neighbor. If they want reduced setback provision, and at the same time this pad 0.0 meter setback, that is also being compromised. I think these are the two major concerns we have at this point. Is there something we can suggest, if not all the way up to there, maybe a bit less, where staff feel comfortable, or that retaining wall provision can come? Maybe we can work with them on that note and come to a solution, because I can see this is genuinely they are doing or they're trying to do with some good intention, and there's a safety component as well. Truck may be backing up now, but if we provide them a little bit more room, maybe not all the way where they want or up to where they wants to go, if we can be a bit more flexible on that, so we can achieve their goal at the same time with the city, and the place will be more safer when those trucks turn in and out. So what is the best scenario we can propose here? I'm not suggesting myself to have another deferral, but it should have been like, but the problem is the discussion is happening now, and then only committee can decide something. And obviously we don't want to hurt the business. At the same time, we don't want to compromise with the safety. But if we refuse it as is, I don't think so those trucks will stop turning. But if we provide them a bit more room for them to turn to back up to those docks, I think that'll be better, and that will be the win-win situation for everyone. So what is the best proposed scenario we can move ahead with?
Yeah, through the chair, just to make it clear, we were never of the opinion that no modification could happen to the 12-meter buffer. In my opinion, I believe that we stated repeatedly that we did have some flexibility, and unfortunately we never received a proposal for anything that was less than what is essentially shown on the drawings that you have received. This is the first time that I'm necessarily hearing about extending the retaining wall. My first reaction to that would be that's better than nothing, but doesn't necessarily fully accomplish all the goals of having that landscape buffer. Two other quick points, I suppose. We never received truck swept pass for the two other loading docks that are existing on the current building. It is just the one that you see there today that I have ever seen. And based on the truck movements, that is the easiest one for the truck to back into. Our transportation staff has said that in order for the site plan application to be able to proceed, we would want to see truck movements for the other two docks. That was communicated, but unfortunately haven't received that information yet. And again, for trying to find a compromise, we have suggested different ways that seem like they would be able to accommodate trucks moving, but unfortunately they would involve other reconfigurations of the building. That, in our opinion, is the only way to be able to secure something that is going to work for trucks to be able to move successfully for all three loading docks, while also not compromising this full width of the buffer that they have proposed. That is something that I feel was communicated fairly strongly. We just never received a proposal that can meet what we stated there. So.
Okay, so a couple points there. First off, all the way back to the pre-consult. I'm not sure if you're there because Neil was the lead planner who's recently retired a couple months back.
Neil Grady.
Yes.
Okay.
Yes, and we worked through a lot, collaborated a lot with him. To at the end of the day, we've provided swept path analysis even 2 years ago that indicated why we needed that distance, and for over a year we've been waiting for a proposal of where are you guys at, because we're showing you why there's a need for it. The other way it has to be, we understand there's a setback, where can you guys bend to understand where you guys are at, as opposed to zero, which has been zero early on in discussion with a potential opening to get to this point with the committee. So I feel like we've been willing to provide information. I think at the last meeting where we first met you about a month or two ago, that's where some additional swept path analysis have come up, which we've provided. And the intent here, because we showed, yes, it's the one closest to the white area of the building, it's because it indicates, at a minimum, this is the extension that we need based on what you show. Any other dock door would indicate a worst case scenario, would indicate we need even more than what's shown on this drawing.
Can I just jump in on that?
Yeah.
This is an existing door right here. That's the one we're talking about taking out. So we did the program for this one door because that's the easiest one to get to coming in. If there's already a trailer here, it's almost impossible to get another trailer in here. Impossible. we don't receive only trailers, we receive smaller trucks as well. So once that truck is in here, to bring it, if that truck is there a 53-footer, even with the extension of the lot to the fullest, it'd be very difficult to get into the other door. So this is really down to one door. That's what it is.
So what I suggest, what I see that the property owner is willing to pay for the wall if that's necessary for the continuity from another side. I guess what I honestly feel after listening to both the sides, you need to come up with some sort of proposals, that one scenario versus two scenario, and work with staff, have a meeting with other departments, and especially Daniel is really good for those, and I can see he's flexible and willing to work it out in the situation. I guess that's what needs to happen in this case. So we can achieve at the same time. I don't want to compromise too much with, so we feel something satisfactory that what we have done.
So I understand, we propose that we sit down again with people here at Brampton and try to come to some consensus or agreement.
Exactly.
Assuming we do that, I don't know how long that's going to take, because I've been at this for 2 years. And it's getting a little long. I'm not blaming anybody, but it's just getting a little long. Which means that I can't even if I had a permit today, it's still taking another year to build this. Okay? So we're talking a long time just for a little 4,000 square feet of building.
I know, sir.
So the question is, we sit down with these gentlemen and we come to an agreement. Do we still have to come back to committee and get an appointment 6 months later to do that?
Not really 6 months, but we'd like to give some time and.
Can we do that by January?
Yeah, that's what I was going to suggest, if that is something workable. But of course, I need to ask the staff, but initiate the discussion as soon as possible and go back and forth, and maybe one department can satisfy another one, and then we have a better, more informed, and again, I have no intentions to delay any process. If anyone wishes to move ahead, we are here to make the decision. But end of the day, what we are here to achieve, we are here to achieve a positive outcome where you feel comfortable moving ahead, because it's your investment, you're a business owner, you're providing jobs there. At the same time, the city have procedure and the guidelines, and we want safer environment. So without further going much into discussions, I think what we need to do, we need to not exactly how much you want, but maybe you need to sit with the staff and work with, offer some proposals, and maybe in some of those discussions when we meet here next time, we'll be having better proposal. And I would definitely like to cap this with a timely manner, so all parties involved here have some sort of accountable, including us.
As long as we put a target time that we can get back into committee by, let's say, the end of January at the latest, because we're running out of a window completely.
Yeah, no, I can
take
clearly
6 months to
understand
get
your
approvals
situation
on
and
the-
frustration.
Sorry?
No, I can clearly understand your situation and frustration. I don't see it should take that long as you're mentioning. Maybe I don't know. I'm not in to comment on that one, but obviously we can. If it's taken that long, then it should not. That's all I can say.
Okay. Anything else?
Yeah, no, I think there's nothing else. I think next up we have having another meeting booked. I'm under the belief, because we have proposed various modifications for the aesthetics, again, even to the point of, we talked about the building, putting in, it's a regulated food facility, so there's only a limit to what you can do in the building, but.
Sir, sorry to interrupt you. There was deferrals in the past. That was your job as well, to get in touch with the staff and go back and forth and give them some proposals. Not that if you're gonna be adamant on certain distance, of course, they're gonna be coming back with the same staff report. That's your job to, even if you are here today, for example, and I'm sorry, I'm not mean to offend you. It's good that you're coming with some aspects, but what is your proposal today? We could have made that decision today if you would have prepared something, some different options in some sort of, like if not this one, like this is what you're here to propose, and if staff is some sort of, okay, the committee was willing to move ahead, but all we come back with, you want A and staff is willing to give B. There's no compromise or there's no willingness I can see. So in the event, we are going to give you a future date. I want, especially you, because you are the one who's going to be supplying all those necessary proposals or the documents or the changes, to the staff, to the back and forth. When we hear on the whatever the next hearing date, what I would personally like to see, obviously staff will have their position, but from you, not just this standard report, like in the event if you're proposing something, A or B or C, like what is their, where your business can achieve, and we can look at all different things.
Could I just add one thing? Notwithstanding what you're saying, where does the committee sit right now? Are you prepared to give us some offer right now on the proposal?
To me, if right now I can speak for myself, if at this point, given the circumstances, I'm going to go ahead with the staff recommendation.
Which is?
Which is the way staff wants, which is to refuse number one. That's why I'm fully sympathized with, and it's not that I'm doing a favor or the committee doing a favor. We for the I would say for the public interest or for the safety, and we value your business. We are willing to give you extension, but there has to be some results we are looking within that extension, and staff is willing to work with, but have those discussions, meet, and try to come to some sort of
okay. So can you give me your commitment that staff will meet with us in the next 30 to 45 days, and then we'll be able to come back to committee by January? Because I don't want to come back to committee next April or May.
Sure, no problem.
We'll come back with what you're saying. To the way I understand it, you want a hard proposal. What we're prepared to do, everything, whether it's building a wall and so on. You want all that in one proposal, whether they agree or not.
It's actually, it's your willingness to do all that work and pay the cost and stuff. That's why we are lenient towards another deferral, and we value your business and your commitment and your history with the city of Brampton, as you mentioned, right? So I guess January 21st we have a hearing date. Maybe.
Is there a hearing date now in January?
The 21st.
Do you have a date?
21st.
21st?
Yeah.
Okay, so that'll be the date.
But when is the submission? Sorry?
Through the chair, I need clarification on whether or not the agent is requesting a deferral,
Are
or
you-
if it's staff's, or if it's the committee's recommendation.
The point is, are you requesting a deferral for January 21st?
If you are refusing, if you're agreeing with whenever one, yes.
Okay. So, Ms. Myers, the submission date for January 21st.
Through the chair, the filing deadline for any new information, as suggested, would be December 10th.
So,
excuse me for a second. Is there anything in December? Is there a committee available?
But sir, the submission is way early. Yeah. There's only one hearing in December, so that would not work for you.
Okay.
I know you're trying to do things, but
I gotta get back to the office.
we appreciate that you're willing to do, but at the same time, we don't want.
So the submission has to be done by December 10th. Is that what you're saying?
To meet,
yes.
Yeah,
to meet that date of 21st. Okay.
Yeah, which would mean that we would need to meet.
You guys need to meet sooner than later.
Yeah. Okay.
Okay.
And in fact, Daniel, if you don't mind, we can talk.
Can we
just
talk
next
afterwards?
Staff has repeatedly said that we're always willing to meet to discuss. I just want to make one thing, to state that, again, we have tried to work throughout this process, and we're certainly willing to continue to try to find a solution. But if we come back with 4.43 meters being the requested buffer again, I would say it is most likely that we will have the same recommendations. So I just want to make that clear before the deferral happens.
How about if that change, if there's some provision of the wall or something, if maybe we can look into that perspective?
Yeah, again, so that's why I say most likely. But again, if 4.43 meters is proposed again, it's most likely that my recommendation will not change. So again, I think that's something that was communicated off the start. We haven't been able to find a solution yet. Of course, we're always willing to continue trying, but.
Can I just ask one more question? He says his recommendation would be at 4.4 meters, he would not recommend it. Does the committee ever overrule their recommendations?
Sir, that's up to the committee after listening to all the sides, how they want to proceed.
I just ask the question.
Sure. Ms. Power.
I think out of all of this, the biggest thing that I've gotten out of all this is you guys were in communication with the staff prior. Now that there's new people on staff, you haven't been communicating. You now have a new plan. Staff haven't seen the new plan, right? What it tells me is that you have two sides that are willing to work and come to a compromise. You haven't talked about it.
And you want us to make that decision when both of the parties are not communicating?
Right, so what we're saying is, take the deferral, you have until December 10th to submit all your paperwork, after you've spoken to staff, right? So set up a meeting with Daniel, he's very good, he can get it all done, and then come back to the committee on the 21st. Take the deferral, and...
Just on that note, for the record, it's not staff's responsibility to reach out to you. It's your job to reach out to the staff so then they can respond. If you're not gonna ask or you're not gonna be in touch with them, they're not gonna reach out to you, what do you want? You have to ask what do you want.
Fully understand, we understand. Carson over there has been contacting me every week on this for the last 2 years, so fully understand. Thank you.
See you on the 21st.
See you on the 21st. Thank you.
Through the chair,
Sorry, guys, please.
Wait a minute.
through the chair, we've not had a motion on the floor for this deferral.
That's not
So
fair. Wait a minute.
my request, please do not communicate like this. Please stay here, don't go anywhere. If you're gonna go, then I'm willing to go ahead with staff recommendation. So stay here, please. Staff, do you think January 21st is appropriate for if there's a new changes comes? We have the time, you think?
Yeah, through the chair, in my opinion, there's plenty of time between now and December 10th to work out, as long as we can have that open communication.
Okay, fair. So looking for a motion to proceed to defer January 21st by Mr. Powers, seconded by Ms. Marcus. All in favor? This application has been deferred to January 21st.
Okay, thank you for your time.
Thank you.
No problem. Dude.
Calling application A19-149, Dal Dewitt and Niraj Dewitt. The property is located at 77 Faywood Drive.
Hello everyone again. My name is Salman Ilahi from Conserve Architecture Inc., representing the client Dalit Dewitt at 77 Faywood Drive. There is an as-built low-grade entrance in a side yard without a permit. Some time back, the client received a notice for a second unit dwelling, but they are willing to keep this entrance as a principal means of entrance for the second unit. In order to achieve that, we need this minor variance application approval so that we can show in our building permit that where the tenants they are coming in. So the relief is for a below grade entrance. As per the bylaw, it says that 1.2 meter, but right now we can have it 0.16 meters. So I'm open to the comments from the staff.
Okay. Committee members, any question, comment, concern at this point? Seeing none, anyone in the audience wishes to speak on this application? Seeing none, staff, could you please weigh in your comments?
Through you, Mr. Chair, the application is supportable subject to the following conditions. One, the extent of variances be limited to that shown on the sketch attached to the public notice. Two, the owner shall obtain a building permit within 60 days of the decision of approval. Three, the drainage from the below-grade side entrance must flow onto the owner's property. Four, the below-grade entrance shall not be used for an unregistered second dwelling unit. 5, drainage on adjacent properties shall not be adversely affected. And 6, that failure to comply with and maintain the conditions of the committee shall render the approval null and void.
Okay, so do you understand and accept these conditions?
Yes.
Okay, if no further discussion, looking for a motion to proceed.
Motion to proceed with staff recommendations.
Motion to proceed with staff recommendation by Mr. Power, seconded by Ms. Marcus. All in favor?
Thank you.
Calling application A19-152 Dixie Holding Limited. The property is located at 10 Henderson Avenue.
Still good morning.
Good morning, members of the committee. My name is Eric Mertzu. I'm the agent here on behalf of the owner at 10 Henderson. We were here previously and we recommended a deferral in order to have some discussions with staff with regards to our variances. We're still requesting to permit a personal service shop on the existing building, as well as to provide a reduction of 3 parking spaces, so it'll be 32 parking spaces instead of 35. We've had the chance to speak with the planner, Mr. Vandenberg, on the file, and I guess there were some concerns with regards to more of the process that would be required moving forward with any kind of development applications or variances. Having that said, we've gone through the staff report. I do have a few comments I'd like to touch upon. And then kind of go from there. So we understand that the area, that general area, is somewhat under transition, or will be in the near future, I suppose. It is a central area in the OP, which does permit for business uses. It's a historical industrial, I guess, use at the moment. But as you're aware, there was a variance for the same building a couple of years ago. I think it was 2016, and there are other uses that have been introduced into the building, more along the lines of a commercial use, I guess you can say. There's I guess a recreation and a gym type use in there as well. So it's not necessarily industrial per se anymore. And we do know that next door there was a recent application through the planning committee to proceed with I guess a medium to high density residential development, which is rather large in scale. That's kind of fresh, and we're not sure how that's going to proceed and what the implications are with that yet. But we'll follow that nonetheless. So the OP does permit for many types of uses. I guess there is business uses in that sense. The services in place now serve the immediate community and more in a practical sense, and they do promote local businesses to thrive in that area. So I think, given that, we feel that the use we're permitting is, what we'd like to permit is a personal service shop. It's minor in nature. It's 63 square meters. We require 3 extra spaces of parking in reduction, and we feel it's minor in nature, and there is a need for it in the community. The owners expressed it. The tenant has interest from the neighbors and from adjoining landowners, and he feels the need. It should be put in there as a minor variance.
Okay. Any question by committee members at this point? Seeing none. Anyone in the audience wishes to speak? I guess no one. Mr. Vandenberg.
Thank you, Mr. Chairman. As you know, in the report, staff is not in support of the application. Just a little bit by way of background on this.
Please.
It's clear that this building is undergoing, with this previous variance and this requested variance, undergoing an evolution away from the historical industrial use to a different, in this case, commercial use. To be honest, from a planning perspective, we don't really have an issue with that, and actually I think this could be potentially a really interesting, cool project and something that could be a benefit for the neighbor, to of the evolution of the building. However, really our concern is one of process. So in the secondary plan, the area is designated for residential, medium-high, high-density residential, rather than commercial uses. And also, just overall, the official plan amendment, zoning bylaw amendment process is the better process to look at the site comprehensively, including establishing the long-term vision for it, the full range of permitted uses, and setting development standards to address any potential impacts, like parking, et cetera, on the neighborhood. But also, going through that process avoids a situation, and we've had these in some other places, where the applicant has to end up coming in repeatedly for variances anytime a new use is proposed. That causes delays on their end, because every time they have a new tenant, they have to come in for a variance, and then cumulatively, you end up in a situation where the work and the time involved in the variances processes exceeds what you would have required, what would have happened if you just gone through the zoning bylaw amendment process in the first place. And it's our position that's really the best way to handle this application, and it's better to do it right the first time than to have repeated variances over time.
Exactly. So, back to the agent, why committee, not that channel?
Well, I think the previous variances were among, I believe, the first ones he achieved for that building that were approved at the time. So the thought of rezoning the whole property for something long-term wasn't really in the cards, whether it be financially, applicable or appropriate, or whether or not there was a need for the actual uses, which there was, and that's kind of why he went that route. The same thing goes for this one. I think that it's such a small, I guess, use in a variance, and it's such a low impact on the in the immediate community. And there is a need for it. He does have a tenant that wants to start a local business there. I think, that is kind of what is deemed desirable at the moment. Now, that's not to say that in next 5 years, 6-7 years, the transition of the neighborhood will show some improvements with the market, and maybe he does want to rezone for a higher density residential development, such as the neighbors are trying to do, I guess, next door. We don't know if that's going to happen or not. That's a very new kind of transition. So I think until there's more indicators until that time, he does want to kind of play it safe. There is a need for the local business there to come in and start operating, and like I said, it's low impact. It's not going to change the I guess you could say the landscape of the area so much immediately, and until such time that there is a need to proceed with a long-term permanent development, I think this is appropriate for the interim. And the owner has expressed, until that time comes, he will, he will be interested. He is interested in redeveloping the site, but the time has to be right for it. That's all.
In the previous meeting, when we granted deferral, there were some concerned neighbors came as well, and they were not really happy with some of the activities on the site. So there were some serious concerns with the parking and the street parking, and some other activities, as per, like, one of the neighbor came and we included. So that was one of the concern as well. I just like to ask from both to the agent and to the staff, did we look at some maybe temporary time period or something? That is something ever was part of a discussion, or we thought about that, or something is even prudent, or how?
Through the chair, this is ultimately up to the committee, and depending on the way you wanted to go forward with this application. But one potential condition would be to approve it for a temporary period, and that include a requirement that they obtain a rezoning and a secondary plan amendment during that temporary period.
Thank you, Mr. Chair. I I think it's not necessarily the period or the length of time that the owner has to operate the business. It's just, it has to be the right time. So we have no issue with, example, if things do change in that area, the climate changes in terms of like the economics, we can submit an application for rezoning, in the future for residential or whatever it be. We'd prefer not to have, be limited by that. Because we just don't know what's going to happen and when it's going to happen. Having that said, we are open to, like, I have some conditions here actually, just kind of drafted, if I can pass them on to Ms. Jean Myers. They're just very kind of conditional, but there are some other ones we'd be willing to discuss with staff if you're open to conditional approval.
You just put it on the screen up there.
Oh, sorry.
Okay.
In addition to these three, sorry, I did want to add a couple. I'll let you go over those. There are a couple others that maybe are more appropriate to add. So the first one is just to permit, the use within that space, 63 meters. Second one is to just follow the sketch that we've submitted to the staff and the public. And
Staff got the copy?
sorry, I think I misplaced a few of them. There's three here.
Would you like to comment on this, or?
Did you mention that you were looking for some additional
so
conditions as
that's
well?
right.
I heard you say that.
So through some discussion with planning, there is, we'd be open to adding a condition for a limited or scope site plan. I know the parking lot is a bit, it needs improvements, and it needs to be delineated with proper dimensions for parking stalls right now. And that was previously brought up by staff. So we'd be open to obviously making those improvements as a condition through a scoped or limited site plan. We can add that in or word it, I guess, however staff prefer. The other would be, more importantly, to address Mr. Vandenberg's comment, we'd be open to a temporary condition of, I don't know, X amount of years, let's say 5 years, but extended at the discretion of the Director of Planning, if that's possible. I don't know if that has to go through planning or committee, but if it's possible to get, just in case, things change in that area, we want to have that option. If things don't change, we want to have that option as well.
Okay, back to Mr. Vandenberg, and then I guess Mr. Power wants to say something, but Mr. Vandenberg, to you.
If the committee is inclined to approve this, staff would, I think generally those conditions are appropriate. We would suggest some additional ones as well. Some of these have been referenced by the applicant. So one is that the use not be established until such time as the site plan has been approved and all related site improvements are implemented to the satisfaction of the Director of Development Services. As noted, right now, for example, the parking lot is not striped at all, is being used inefficiently, and is maybe causing some of the parking on the street there, because when I visited the site, the parking lot was pretty empty, but people were still parking on the street.
Through you, Mr. Chair, can we have something in there in regards to that parking? Because that parking has overnight parking and storage parking. So there's a boat sitting there, there's a truck sitting there, and it stays there constantly, because I actually live in that neighborhood.
Okay.
So I know that neighborhood very well, and you know what? The parking has to be a private parking for that facility and that facility only, so that alleviates the street parking. Right? If you're not willing to alleviate, and the cars that are, the current tenants that are in that building are parking on the street, they're not parking in the parking lot. I've visited the site more than 3 times, and they're always on the street. So that's where the concern is with the neighborhood and the other people in the neighborhood, is that street parking. So if we are going to approve it and go along with these 3 conditions as well as the additional conditions, we have to put in something for parking, because it's not effective in that area.
Yeah, and I would.
And no storage of any kind, so no boats, no trucks, no planes, no whatever you want to put there.
Yeah, and yes, I would 100% agree, and that would have been one of my other suggested conditions, that not be storage of trucks, trailers, any outside storage type. There are also vehicles that are inoperable, none of those should be stored in the parking lot.
So can we have wording, Mr. Vanderwerf, if you can suggest if you want to modify these conditions or add some, if we can have properly wording so we can move ahead.
Yes, so I think the first one of the site plan is our standard wording for site plan.
Is that the limited site plan or the site, I guess limited?
I think we typically would leave it open, but I think this very well may be a limited site plan application.
Okay.
So the other, Elizabeth, do you want to?
Sure. To address Mr. Power's concern through you, Mr. Chair, I would propose that a condition be added to state that all outside storage, including oversized motor vehicles, boats, etc., shall be removed from the site. Parking shall be used solely to support the permitted uses operating inside the building on the same lot.
Okay. And this 63 square meter, is that something makes sense? And okay.
Through the chair, we do have a couple of other suggested conditions as well. And the next one is that the owner obtain a building permit for a change of use prior to occupancy of the building for the personal service use. That was something that was requested by the building department. And then if you are inclined to have it as a temporary period, we would suggest the wording be that the variance be approved for a temporary period, and we may suggest 3 years, or for an extended period of time as approved by the Director of Development Services, and that the applicant submit and obtain approval of an official plan amendment and zoning bylaw amendment for the property within this period.
I'm okay with most of the last condition. Actually, all the conditions are fine. The last condition is okay until the last very little bit. We don't know I don't know if it's feasible for us to submit an official plan amendment application within that temporary period. Now, would that be, through Mr. Chair, the staff, would that be if, you did mention that an extension through the Director of Planning. Now, is that prior or after a rezoning application would be made? It would be, like if the Director approves an extension, then what would happen with the rezoning application, for example? Like at what period would that have to occur?
At what period would the request have to occur, or?
Well, the request would have to occur before the temporary period's up, right? Yeah. And then I guess, let's say like we needed another year or 2 years, for example, a year, let's say, a rezoning application would have to occur within that extension that had been added. Is that
Well, I think one thought with the extension is that if the application is submitted within the 3 years, and for whatever reason the timelines for the rezoning are not completed within that 3-year period, then it would be appropriate for the Director to provide an extension.
Are you okay with that?
Would we be able to extend 3 to 5 years?
I'm okay with 5 years too, given the fact that if you're looking for a lease or something, then the contractor is.
That would provide a bit more certainty in terms of timing.
I guess
3 years go by so quickly. Yeah. I'm okay with
even 5 years goes quickly.
Yeah, no.
But anyway, I'm okay with 5 years.
Thank you. With that caveat as well, with the.
Staff, to Mr. Vanderwerf, 5 years something for the leasing and the contract, something, I guess that will be good for them as well. And in that way, the staff has still control, and it's not that, something is proved and things are out of control. So I guess that's achievable and win-win situation for everybody.
Yes, so just to confirm the wording for the last condition, if I can hear.
It's temporary period of 5 years, and maybe Mr. Vanderwerf or Ms. Corzola can suggest it.
Yeah, if you don't mind.
Through you, Mr. Chair, I would simply recommend that the variance be approved for a temporary period of not to exceed 5 years or 5 years.
Yeah.
I don't know if you want to include David's flexibility to extend that period should approval be sought from the Director.
Yeah.
the applicant during that time submit and obtain the official approval of official plan and zoning bylaw amendment.
Sure. Or if anything changes, come back to the committee at that time.
Yeah.
Right.
So,
That's all.
okay, so I just wanted to make sure that the last part was still part of the condition for the temporary period, that's all. Okay.
Okay, if everyone understand and no further discussion, you want to add something? Please come here and your name and address for the record, please. You are the owner of the property, right?
Yes, I am Manish Sasi. I am the owner of the property. I own this property from 1998 until 2015. Until 2018, I had a good business. I was able to maintain and create jobs. After that, all the jobs have moved out, and we had difficulties. In the meantime, city has granted permission for a public organization for disabled people. So the neighborhood had problem with the people. However, I'm trying to work with those people and try to run a business. I had difficulties paying even the taxes for several years. I have paid in fines alone closer to $100,000 to the city. And in 2016, I got permission somewhere in 2008, I guess, for a school. I couldn't find tenants. And 2016, I managed to get permission for gym and a physiotherapy clinic. And nobody wanted to rent the place because of the location and the neighborhood. But however, struggling against that, I was able to maintain that. And at the moment, I have rented for commercial around 30% of the property and trying to improve the area. I know the parking lot have to be repaired and all the neighbors are parking in my parking lot. I feel hard to go and tell them not to park. In fact, the person who complained the other day, after leaving here, I met him at the elevator. I introduced myself to him and I told him that I am the owner of the property. He apologized to me and he said he will come today, but he couldn't make it. And it was a misunderstanding. He is one of the person who parks in my parking lot every half hour. I don't say anything as a neighbor in the neighborhood. And I am cleaning needles in my parking lot, which is true, because if I am not occupied that area, there is no safety. Because my things are going on, people are coming and going, it has become a safe neighborhood. And I am working closely with the police as well as with the other departments to keep that area occupied with the safety. So if you can kindly understand my position, I'm trying to create 2 jobs to 2 employees as well as trying to make some income. I had to repair the parking lots. I will do all new by next year by May, because now the time has already gone. I can't do the new parking lot now. And also, if I am going to promise somebody and offering a job and a workplace, I had to be reasonable also to them. For when they started doing the things, I am spending closer to $50,000 just for this 1,400 square feet area, 63 meters of square feet area. And 2 people are going to build up a business. For them to do the things also, I had to be reasonable. If they maintain everything in order without violating any city violation, I should have a permit to continue. So it's my kind request, if you can kindly understand my position, and I am trying to do something good to the place, not that to create any problem to any neighbor or anyone. And I will go after the people. There is no one supposed to park in the nights. But I will go after and I will get rid of the vehicles and I will try to put some signs also. Thank you.
So, thank you for coming forward. The city and the committee, they are in fully support of the business. We want businesses to do well, first of all. At the same time, we understand your hardship and maybe it's the location and the change of the businesses. Oftentimes we have seen these applications. I would encourage you, we want your business and your property to be fully occupied. In the future, if you manage to find any other tenant, you're more than welcome to contact staff and be in touch with them, whether how city can help you out so you can have more tenant occupied there. So, in other words, you can look after the property in a better manner where you're collecting good rent, you have more solid tenants, they are not running away after some time. So the property, once the property is in good condition, then the neighborhood obviously they will be happy with you and your property. But thank you for coming forward. At this point, what I really suggest, maybe if we can remove that part, if that's proper, about making that application within that 5-year period. If that is something we can look into it, and we just propose the condition that 5 straight year for the temporary period, and rest of the conditions can stay as is. Are we on the same page, Mr. Vanderwerf?
Yes, we are, I think, and just to confirm the conditions, I think it may be useful just to confirm the conditions. So one is related to obtaining the site plan improvement,
Yeah.
or site plan approval and making the improvements.
Limited site plan?
Yeah.
Okay.
And then the obtaining of a building permit for a change of use, as well as, and the conditions that the applicant has suggested, and then also the condition that Ms. Corzola suggested regarding the outside storage.
Yeah.
And then the
Temporary period of 5 years.
Temporary period of 5 years.
And
that they submit the rezoning and official plan amendment application during that period.
I was actually suggesting not to include that part.
Okay, just for 5 years then.
Yeah, just 5 years, and for the extension, Director of Planning's discretion to extend, or, no, sorry, that was with the zoning and planning.
Yeah.
So straight 5 years. Sorry, my apologies. I get it. So committee members, we all on the same page? Sir, do you understand and accept these conditions?
Yes, thank you.
To the agent more than the property owner.
We're fine.
Anyway, if no further business, looking for a motion to proceed.
Motion to proceed with the 6 amended conditions.
Motion to proceed with 6 amended conditions by Mr. Powers, seconded by Ms. Marcus.
Absolutely.
All in favor?
Thank you.
This is approved. Thank you. If no further business officially, then looking for a motion to adjourn
Motion to adjourn.
by Ms. Marcus, seconded by me. All in favor? This meeting is officially adjourned. Thank you, everybody.